Oh, from the other side.
We've informed the other side.
See, the last time Mr. Jana appeared for the state.
Jana, yeah.
Do you have any
He's not
clue?
there.
Do you have any clue?
No.
That's the whole difficulty. That side, this problem is always there.
In fact, they had given a compilation to your lordships, and your lordships.
I know, but I need to know the status of the investigation.
From the last time till today, I can say with certainty that none of us have been called. There's nothing which has been taken from us. So your lordships
They might have chosen to file a closure report.
They had given a compilation which your lordships wanted to see. Copy was not supplied to us, but your lordships had been provided that compilation.
Yes, are you appearing in that?
No, I have no knowledge.
He's appearing for the.
Jana was appearing.
Huh? Who will appear from your side? That's the whole difficulty. Last time Ms. Jana appeared. This time somebody else will appear.
It is to alerted by.
It is allotted to whom?
Ajay, it is to alerted now. When he is not in the list.
You ascertain because see,
Yes.
the entire thing depends upon you. What have you done for such a long time?
The complainants are before your lordships. The only thing that your lordships are considering if they're.
But I want that IO to be
one
present
part
in
is
the court.
status, the other part is the crossing of affair. That's being considered by your lordships.
See, even if I
So-
put it at 2 o'clock, the hearing may not take place because of the IO's absence.
I have no difficulty. I understand. It's also not on.
Why can't you do one thing? Short date next week, whatever you want.
Because I
You tell us so that I can
Yes.
ask the IO to be here.
Yes, I do. So,
Yes.
if I understand it's a short notice, 10th or 11th Milords is either Thursday or Friday. Otherwise, Milords, 22nd.
Okay, 22nd.
22nd will it be?
22nd.
No,
At-
22nd we have some difficulty.
Yes.
You also can fix up
We have
15th,
to start. Milords.
16th, 16th,
last-
17th. You also
The
can.
22nd, let them start.
Yes.
them start.
Let them start 22nd,
Yes,
no
please.
problem.
Yes,
We
please.
have to start.
Okay,
Milords.
primarily, I want to hear the statement.
Other than the prosecution.
That's the
Three
primary.
occasions they have circulated letters, etc., on the complainant side. If anything, these
See, the
start-
complainant may not get that extensive hearing at this stage. Complainant may not get that extensive hearing.
Yes, yes.
See, it is the
We'll
process-
just assist.
The IO is investigating.
Yes.
The IO, whatever the IO will say, that they are agreed person. You are,
Lordships is correct.
you have given to
We
motion.
will only
and Let
assist.
them do it. How are you concerned?
I think it's a.
Of law, that's all.
Otherwise, also you are bar under 302 CRPC, I think.
No.
You can't get a complete hearing on the at this stage. You have started a criminal complaint and police is investigating. It's all right. You can assist, but the primary hearing is from that side.
That is correct.
Mr. Naik,
22nd April.
shall I take it that you are appearing?
Yes, ma'am. Now.
Shall I take it that
on
you are
that-
appearing
on that
or
to
somebody?
My runner agents to take this, sir. On 22.
22nd, I need the IO to be here. I need the IO to be here along with the case diary and all. Because I think he has not done anything thereafter.
22nd.
That's what they say. 22nd at let us make it 2 o'clock so that it will be
I'll be-
easier for you. Okay. 22nd at 2 o'clock. We'll hear them.
Right,
Need-
right, absolutely correct.
I'll accommodate you that.
So we take leave from my lordship.
Yes.
I have one small request. The Lordship may pass that order because otherwise the matter may not get resolved.
It's not there in the list. How can I pass that?
Even last two occasions.
Or the lordship can directly master.
May I suggest their memo. Lordship may direct the registry to list it on 22nd on their memo because they have filed a memo.
Yes,
Give the memo. And I'm asking you to please assist the court and tell on 22nd at 2 o'clock. The IO should be here along with the case diary. Note it down and
Yes.
okay. 2 o'clock
Yes.
and 22nd, the IO along with the case diary. Thank you.
Most of them.
My matter was last Saturday Milord. I mentioned for illegal your lordship says Milord.
Yes, yes. Yeah, I remember. I remember. IA, the IA will come.
For illegal.
I told you. I remember.
Most of them.
I have a case of matrimonial dispute to drop the earlier with accused persons along with the victim. The in-laws and wife.
498 A now.
were there.
498A,
Yes, my lord.
matrimonial dispute.
Yes, my lord.
You have settled the
Your
dispute.
lordship are also directed to mention and it will be list.
Have you settled the dispute? Have you settled the dispute?
Have you settled the dispute?
Dispute is settled.
Dispute is settled.
Okay, give the. Matrimonial.
That's private issue. It's a CRLMC matter. It was earlier listed, that has been delisted.
Yes. Give the memos, we'll see. Give all the memos. Give all memos. We'll see. Give all.
Pray, my lords, can it be listed on 11th your lordship? And senior Mr. Mishra will be physically present on 11th your lordship.
11th, I don't know whether it can be heard.
And it's a provisional pension has been started, your lordship.
Criminal appeal pension, what is the link?
Provisional.
And if you do, you are convicted, everything will happen and take it on. Accommodate.
11th your lordship.
Yes. Yes.
Item 4.
What do you want? 89 round.
Two matters.
Two matters, huh? Okay. You're free. Yes.
Item 8.
Can I call?
Yes, yes.
List, page wise so that it will be clear. Yes.
Page number 1. Item 1 to 7.
Item 4, my lord, 4 weeks after. Kindly urgent.
Okay.
Item
On the
2, my
request
lord.
of petitioner? You have a petitioner? Okay.
My lord, item number 2 next week, man.
Huh?
Item 2 next week.
Not next week. It will go to after vacation.
Right.
Enjoy vacation. Okay.
Problem.
Item 8 to
Item
21.
number 5.
5.
Item number 5.
Fine. Sir. Yes, ma'am. What do you want?
Urgent correct.
Okay. On the request of counsel.
Item next week.
8.
Next.
8 to 21. 22 to 36. 37 to 47. 48 to 54. 55 to 59. 60 to 68. 69 to 73. 74 to 81. 82 to 84.
Item 63.
Can be taken by along with CRMC 1367.
How it is related?
That is matter already compromised. The same matter. Matter already I have taken the permission.
63.
Yes.
Lease the matter along with the
1367 next week.
reception.
Matter already compromised.
Settle. What are the offenses?
That 420.
420.
Yes.
Okay. कर दो
1365.
next week देख लो ठीक
Next one next.
yes mentioning VC
Item, my lord, I think, pardon, my lord. Item number 104 kindly taken up after vacation.
104
Item 93 of the weekly list, your lordships.
yes
The matter is ready for hearing, my lords. It has come along with the paper book. So any day this week, my lord, if your lordship takes
why not today
lordship, yes. Lords.
get ready come with written note of submission and all we'll see if it possible I can pick it up today.
Written note of submission, my lords, I'll need a day. If tomorrow, if it comes,
Let us see how you proceed so that otherwise tomorrow. Okay. Get ready with the matter. Okay. Because this is 2012 matter.
12 appeal, my lords.
So get ready, we will finish it up.
Lordship.
Item
Item 1.
Offense 365, 306. Petition for discharge has been rejected.
Rejected.
Nobody is there.
Nobody is there, huh? 2013. Earlier notice was issued. On the request. Nothing is there. Password.
Item 3.
both the parties are present, my lord, and matter settled with compromise. And the offences, those are also compoundable in nature, my lord. Offences 448, 294, 323, 324. All the
Compoundable, then why don't you go there? Why are you coming here? Offense, why 482 then?
379 is not charge sheeted. Both the parties are present, my lord.
What are the allegation?
Allegation, my lord, on the day of allegation, my lord, day of occurrence, some children, my lord, they blocked some jamkuli from the house of the informant, my lord, and for which they scolded, and subsequently 6 persons, as allegation is that they have assaulted and scolded.
Yes, I got
Yes, yes.
was it. Right. Who are they?
I'm for the opposite party, not two.
Two. Okay. How many accused are there?
Only one.
Right. At the instance of opposite party number 2, FIR number so claim to register against the prisoner for a major offense. Allegation. Have you filed an affidavit?
Yes.
And after investigation, charge sheet was filed.
In the FIR, there are 6 accused.
But charge sheet,
Only against one person.
where is the charge sheet? Do you have that?
Copy of the cognizance order I have filed. Here, my lord, charge sheet. This is the copy of the charge sheet.
Give me. Although FIR was registered against 6 accused persons, however, after investigation, the police filed the charge sheet.
They are in the record, my lord.
Charge sheet is the
No, my lord, sorry.
1 minute.
Sorry, my lord. I'm actually sorry.
What do you want?
No, my lord. Charge sheet I've given.
I have taken it. Why are you worried about? Wait.
My lord, sorry.
While giving dictation, why are you
Sorry.
commenting? 6 accused persons, however, 6 accused persons, however, application, charge sheet in the present case has been filed against the petitioner on 26/10/2007. 2007. We learned civil JMFC Niali Katak by its order dated 2/4/2008 has taken cognizance of offence punishable under section 448, 294, 323, 324, and 34. 324 IPC, not 31 IPC. Before the charge could be charge is framed and trial is commenced, the parties have settlement on the basis of the petitioner and opposite party number 2 are present in the court, being represented by the director counsel, identified by them. They've also filed the self-attested copies of their Aadhaar card to establish their identity, which are taken on record. The opposite party number 2 has also filed an affidavit dated 6/8/2024 inter alia stating as para 2 to Nijo, para 5. Yes, he did. Flag it. The opposite party number 2, who is present in the court, will call from the court that states that she has already arrived at a settlement and she doesn't want to prosecute the petitioners anymore. The settlement has been arrived on the intervention of the well-wisher and village entry. Mr. Naik, that counts for the state, submits that the allegations are minor in nature since the parties have settled and filed affidavit. There is no legal impediment regarding head to soul social first. Yes.
Item 6.
Please, in this case, notice already issued to the opposite party. The allegation that the petitioner
Service is complete. No service.
next week, next week.
Service on the opposite party is complete. The petitioner will take first step to serve opposite party. Leaves the matter after 1 week. Yes.
Some personal pattern matter for this admission convict my senior is there.
Mr. Sanjay Das.
Why are you always going in a reverse way or something extra?
You will also leave. I have got one matter in court number 2 old building. So he is mentioning that press admission. खाली admit हो, bail grant, fine stay.
But what will happen to the youngsters those are waiting? And the seniors will take advantage of this.
No, no.
Youngsters are waiting.
Your lordship will second, 1 second, 2 seconds.
Which item? Which item?
35, 36.
35, 36.
1 minute, 1 minute, 2 minutes.
I'll deviate the rule for the today only, yeah? Only for today. Only for today, not for the year. Yes.
35, 36.
Acha, fresh appeal. Okay. Both the appeals are admitted.
So he has got
same.
Best stay.
He has got one matter, I have got one.
You are free now. Yes. Do that, fellow.
My appearance may kind
Appeal admitted.
Best.
Relation of fine, bail granted.
Subject to ଆଜ୍ଞା ମୁଁ ବାହାରୁ ପଳଉଛି ସେ ସଦାବେଳେ କହୁଛନ୍ତି
He is saying his cost, he is correct there actually.
ଆମର ସବୁ ପୁଅର ମ୍ୟାରେଜ
For High Court, the cost will be you take him for coffee and that will be the
ସେଇଟା ମୁଁ ଦେଇଦେବି
Yes. Okay. Oh, me. 1 minute, item 6, not for, I'm sorry, item 6. Opposite party is the only state.
Yes, ma'am.
There is no opposite party number 2. Why don't you tell that?
Matter the matter
To take fresh step on service state is yes.
matter relating to that is 420 case.
Why are you not telling I'm passing some wrong order? And yes.
I think my lord's mind and you have to.
Now it is written that issue notice to opposite party. Opposite party is here.
Yes.
I thought opposite party, private opposite party. Yes. Yes. What is this case?
In this case, my lord, petitioner was doing the event management. My lord, the informant is the ex-deputy MLA of BJP, belongs to BJP. He has lost an affair. Petitioner has promised to pay if he, in case if he paid 20 lakhs.
To whom?
To the informant.
Why have you not brought the informant into? Why have you not included?
That your lordship, that last time I have mentioned. Your lordship notice to.
Why should I? Then shall I draft the petition for you?
No. I will implement him.
You have to implement. You have taken money and what? Why are you not?
In the meantime, 8 months already passed. No charge sheet.
That's right. But you implement the informant. It is a monetary transaction. Monetary transaction.
I as per the Annex 5, I will give the bill that I have taken 10 lakhs.
Okay. Leave of this court to implead the informant in the present case is opposite party number 2.
Yes.
Let him do so within a week. Issue notice to the newly implemented opposite party.
Sorted.
Requisite to be filed. Requisite to be filed within 2 days. Please the matter on short. You please implement.
Today I will.
Yes.
item 7
Emanated memo of parties to be filed. Okay.
item 7
Yes. Service. Pass out.
item 9
The matter is settled between the parties.
I am appearing for the victim informant. What happened in this case?
You settle the dispute.
Again? Settle in the time of incident, the victim was minor. So I have made affidavit of his father, her father. And so also the now victim is major also. Here,
What is the settlement?
settlement is that the proceeding is pending since 2015. No charge sheet has been filed. And in the meantime, by the sweet will of father parents, she has married to another boy. And she wants to continue his marital life in a good and smooth manner. Due to after charge sheet, notice will go, he will come, she will come to court.
I know that.
Only those are difficult.
Let us see what are the allegations.
My lord.
Allegations are
She
serious.
also present and
No, maybe they may.
Yes.
What are the allegations?
allegation that is the
Let us come to
376 is there.
161 statement.
Kintu
Yes.
law of affair, I have gone through the petition. Where next one, annexed that is 161 statement of the victim,
Where is that?
Page 12.
page
Page
12.
12. Please read it.
My
What is saying?
Oh, no. Huh, nah.
Now go put on.
That is there.
81 creating to.
Allegation, tell me the allegation.
81 is cohabitation with the promise to marry. My lord, annexure 2, your lordship may turn to page 17. That is the compromise between the petition opposite party number 2 informant and the petitioners.
Yes.
Notice may be issued, my lord.
I'll issue notice. Let's settle. Let us see. So, issue notice. Okay. Yes.
Item 11. Today this morning I have received the CT. Almost documents. Which means there are some time.
This is a compromise matter, my lord. And I have also filed a criminal miscase because the informant has filed a
Petition.
compromise. Lekhi jita petition le.
No, sir, don't look.
The petition say complainant has filed this petition.
Yes.
That matter has been compromised. And I have received the amount. She has alleged that she has some amounts has been misrepresented one of the accused person. And thereafter some other have been entangled in this case. And thereafter the payment has been made by that person to him. And matter has been settled. What?
He has taken money from whom? From you alone, or he has taken money from others also?
No. This one.
It is a single complaint.
Single complainant.
Yes. Why have you implicated so many respondents then?
I am not the petitioner in this case because the complainant has filed the petition.
You are the accused.
We are the accused.
On the basis of the complaint, some other persons have been arrested in the meantime. They are taking action against Poppy number 4, 5, 6. That's why they have been implicated as a party.
What are the complexity of these people? You are appearing for all the
Accused persons.
Yes.
And
why?
As per
I have got back my money, man.
It's all right, but it is coming to the court means you have to look into. Why?
My lord,
The reverse way.
also. He is present also. On the last occasion.
What are the allegations?
52 pages documents.
Huh?
That is why I have.
Shall I pass it over?
No, not today.
Sorry, Jiva. More would be 482 file korche. Sorry, you said up Charlie.
You have filed 482.
Passing of the on the basis of compromise.
Where is that?
My lord, it is diary number 10337. Number has defect has been removed.
So check with the 10.
10337 of 2000.
And shall I put it on Friday? Both the matter will be.
Yes.
Only I pray those persons have come. Their presence may be noted and it will be easier because they have come from Dharamgarh.
Easier for whom?
They can appear through.
See, the system is working for them. Complainant has filed the complaint. The entire police department has investigated. Now he's coming and saying that I'll settle with it.
That is.
So why grace to them?
Of like.
Let them come. They are accused after all. Why grace to the accused?
No, complainant.
If you have problem, you tell me. I'll account.
No more problem. Complainant has
let them appear.
Through no. Today they can identify through their advocates also.
No, let them appear through BC. No problem.
Both the matters can be tagged together and disposed.
Yes, that's what I'm saying. Shall I put it on 11th or
diary number 11th
11th or 15th? You tell me.
11th.
11th.
No.
11th. And let us fix the time also.
2 p.m.
No, because the reason is if they will appear in the VC, it is better that fix the time. So that
Before lunch or after lunch?
12 o'clock.
12 o'clock.
12 o'clock. 12 o'clock, they will be. Whoever wants to come, they can come.
Yes.
Whoever can't come, they can appear.
Yes. 11th month. Obliged.
Yes.
My lord, item 12 is a compromise matter. Both the parties are present and taken up 2 p.m.
What are the offenses?
294, 323, 340.
Okay.
There is a case. There is 34 is there. Only accused petitions, only one is the petition here.
Yes.
My request,
How many accused are there?
34 is there more than the one, your lordship.
How many accused?
One accused, my lord.
No, your
No.
34 is there.
34 is invoked. Where is that? Where is the charge sheet? Where is the charge sheet?
Not looking, my lord. I have applied And taken up to pay. My learned senior will appear in this case.
Where is the charge sheet? So
Charge sheet not filed, but
That
fact
is filed on 27/9/2014, my lord.
Can I see the charge sheet? You have the copy of the charge sheet. Let us see how many accused are there.
charge sheet not filed.
That's it. I have not filed.
I'll put it at 2 o'clock, but come with charge sheet. Otherwise, I'll have to adjourn. Okay, tell your senior that charge sheet is required. Yeah. Yes.
13 is on quashing of the entire criminal proceeding, the matrimonial dispute. Your Lordship.
498A.
Yes, your Lordship. And the other election.
I'll issue notice then.
Yes, your Lordship.
Okay, issue notice.
It's not the husband.
To opposite party number 2, Mr. Want the acceptance for this. Okay. Okay.
And 40.
Yes, sir.
My pleasure, Lordship. In fact, though the petition has been filed to quash the criminal proceeding, after going through the materials, I think that there is no substantial point to intervene or quash the proceeding. But I have a submission here. Since the charge sheet was submitted showing the petitioner as absconder and 3 SC/ST Act is there, after which arrest he will be remanded and notice will be issued. In this connection, a co-accused approached this honorable court by way of filing anticipatory bail. There, their lordship passed that he will file a petition, notice will be issued on date fixed. So similar order be passed.
Fair enough.
Your Lordship.
Fair enough.
No, one more thing, your Lordship. The present petition earlier approached to this honorable court. Made ABNPL number 15114.
Rejected.
Your Lordship. That, yes, your Lordship, rejected, but there is an order, your Lordship. The coordinate.
What is that order?
Yes, your Lordship.
Where? Can you give me that order?
Subcopy
Is it different than the order passed?
That order I have not with me.
Qua the other co-accused person?
That order kindly. I have not.
What it says is,
yes,
co-accused person filed anticipatory bail.
Yes, sir.
There are some observations in the same line, you dispose it up.
So same line disposal.
That order I have not gone through this order. Lordship can dispose of yours by this.
But if in the his anticipatory bail is something is passed,
yes, sir. Lordship.
I can't pass a contrary order.
Yes, Lordship. One
Do you have
1511.
You are anticipatory bail. The problem is, you are anticipatory bail, it is a simple sheet rejected. I can't add something there.
Exactly. What was the order?
They are request.
Your lordship may do.
Can I take it 2 o'clock?
2 o'clock.
Get that order. Take it and get that order. You just tell me, if even if leader is not there, you can very well. Yes. In that line, I can dispose it up. Yes, sir. Yes. Copy दे दियो तो.
Yes, sir. Lordship.
Yes.
May I please, your Lordship? May I please, your Lordship? The passing of the proceeding on the ground of settlement, a child was born, my lord, and Annex 5.
And in this case, perhaps evidence already been more.
Evidence has
been concluded.
That has been settled.
Case also completion of the trial.
If there is the evidence is being recorded, I can't scuttle the trial. That's the problem.
That has been settled. Even during the appellate stage also, your lordship has power to.
No, but I can't scuttle. After conviction, it may. I don't know. What are the evidence?
PW3 is the victim, your lordship. That is pays.
Evidence I have
Then it will be a disastrous consequences. You know, the victim, everybody goes and depose against you.
But a child was born.
That time also it was there. That time was also there.
That was also there.
Why she has deposed against you?
I have studied the pressure of the.
Those things.
Because he's a poor family, that is the reason. That is the actual reason.
Maybe the reason, but what can I do? You tell me.
Notice they have settled. Annex 5, that's what I can say.
Why she has gone to the court and deposed? If the evidence has come on record, trial is going on. At the fake end of trial, how can I exercise 482? You give me some judgment. If you can, I can very well do it.
No. During the appellate stage also, this judgment of
show me some judgment if the evidence has already been recorded. You see my judgment. In that judgment, specifically, I dealt with this position. Specifically, I dealt with this position. You Rojalin Raut judgment, you just give the citation.
Yes, yes.
Just see. I'll next week. I'll next week. Next week रखो इसको 17th 18th 17th 17th huh?
So Rosalind,
Just see the judgment if
Malak.
you can
Malak.
carve out the exception, then we can do. Yes.
number
16.
May I please, Your Lordship? My lord, the petitioner and the opposite party are two brothers, my lord.
It's not open. I got it. Very slow. नहीं
16.
Yes. Tell me,
May I
I'm not getting the file.
My lord, the petitioner number 1 and the informant in the affair, my lord. My lord, in the month of January 2024, my lord, the petitioner lodged a complaint under Annexure 1 at page 12 regarding the installation of CCTV camera.
Both of them are brothers.
Yes, sir. Family dispute notice 295 34 IPC Lordship.
If you notice, two opposite party number.
OP2 Your Lordship.
Why don't you settle two brothers who installing some CCTV, some fighting?
My lord, the cognizance asset has been submitted and the cognizance has been taken for Alice office under section 290 under Annexure 5, my lord. Till they appear, my lord.
Application for adjournment. Yes.
Item
Shall I send it to mediation straight away?
Let them have to, man.
Hmm?
Let notice go, my lord.
No, notice. I'll issue notice also, and
Why?
I'll send it to mediation because you are brother after all.
But I do not have anything that can be.
Okay. What do you say?
Your Lordship 294 506 34 IPC and dispute arising out of two brothers of a family. Lordship,
I'll send it to mediation.
Yes, that is the
brother,
best. Your Lordship, I think that is the best to do before the
Shall I send it to district mediation or where? I don't have file. Therefore I'm wondering. Yes, I'm not able to retrieve the file. Yes, I got it. It seems. FIR. Where is the FIR? FIR number?
Your Lordship.
Yes, FIR is Bhadrak.
Yes,
my lord.
So Bhadrak district court Bhadrak.
Yes, yes.
Huh?
FIR number, Your Lordship, 191 of Your Lordship, 7/4/24, Your Lordship.
Right on. The complainant is the complainant opposite party is the real brother of the petitioner. Due to minor dispute amongst them, the FIR came to be registered against the petitioner. Issue notice to opposite party number 2. Written notice also may should not be same. Regarding to the nature of allegation and the relationship between the petitioner and the opposite party, I am of the considered view that the matter could be referred to district mediation center for exploring possibility of a settlement. The coordinator is directed from working report after 2 3 weeks in the meantime, in view of the fact that the matter is referred to mediation and the petitioner is activity to no application before the trial court seeking adjournment. Awaiting mediation. Thank you. File the process, File the process. Thank you, petitioner, the counsel for the petitioner also undertakes that the downloaded copy of this order shall be served upon the opposite. Yes.
17.
The petition sister-in-law of the informant, opposite were not to my lord. The matter originated due to civil suit and a land dispute, my lord. And a petitioner number 2 is the brother of the petitioner number 1. While constituting the share of, in their share of the petitioner 1, a house, there is a quarrel. And
who is the opposite party number 2?
No, she in Bhaujo, she nonando. Petitioner number 1 hela Bhaujo. petition on to hele non on.
Will dispute there is 144 proceeding.
Mailor compromise ହେଇଛି.
Issue notice to opposite party number 2, written around so on so. Serious allegations or?
No, matter. ସେଟା ପୁଣି civil dispute compromise ହେଇଛି ସେ civil dispute
Bhubaneswar Mediation Center.
Mailor.
Bhubaneswar Mediation. Same court, yeah. Bhubaneswar Mediation Center, notice for the agar the court same line.
Mail. Stay of the further question. Mail.
Settle the dispute and come.
Mail.
Okay.
Petitioner is the husband, madam. Opposite partner wife, 498A.
Okay, issue notice. To opposite party number 2. What is the stage?
Stage matter now just cognizance taken, madam.
What on the marriage front? Marriage front.
Marriage for divorce petition is pending between the parties.
Is that chance of settlement?
Chance of settlement is there.
Where are these people? Staying, where are these people staying? They are staying at Angul. Which mediation center?
Mediation center, High Court mediation center.
High Court.
Madam. Notice ta jaoga.
Settle the dispute and yes.
So if I may please your lordship, my lord, on behalf of Mr. Dwivedi, my lord, the petitioner challenges Annexure 1, wherein further investigation has been allowed by the learned court below. My lord would kindly for a moment have a glance at the application at
Further investigation is allowed.
Yes, your lordship.
Yes.
My lord would just have the last page of the brief, my lord. The last annexure, the last page of the brief, my lord.
Yes.
My lord, this is the application wherein. I'm sorry, your lordship.
Yes. The petition which you are.
Yes, your lordship. The petition on the basis of which the application has been allowed. My lord, the last line of the.
How are you agreeing?
Yes, my lord would kindly for a moment have a glance at the last page. Under the above facts and circumstances, to comply the directions of Odisha High Court, it is absolutely necessary to reopen.
Where are you reading?
My lord, the last page, the first paragraph, last line, last sentence.
After investigation.
Yes.
Yes.
So your lordship will
Annexure
just-
6 you are reading.
Yes, your lordship.
Yes.
Under the above facts and circumstances, the last sentence, last first paragraph, last but third line.
Yes.
Yes, your lordship. Under the above facts and circumstances to comply the direction of Odisha High Court, it is absolutely necessary to reopen the case for collection of further evidence and incorporating section 109 BNS in the charge sheet.
In fact, I'm not getting that.
Lordship, that page, Annexure 6.
My lord would kindly have.
First paragraph, the 4 lines above.
34, page 34.
Yes, your lordship.
Yes, your lordship.
Read with reference to the caption subject.
My lord, what has happened is they say that the charge sheet has been filed and other things have happened. In the meantime, the informant has filed a case before the High Court. High Court directed them to file for further evidence and to include 109. That is an absolutely erroneous application. Your lordship may kindly for a moment have that. The last sentence, your lordship, last but third line.
Yes.
In the meantime, the victim injured.
Absolutely necessary.
Yes.
To reopen the case.
Yes.
For collection of further evidence.
And incorporating section 109 in the charge sheet. My lord, that is the problem. My lord, they have already made up the mind. My lord, an investigation cannot go.
Does the High Court say that?
Absolutely not. Absolutely not.
Where is that order?
My lord would kindly have the orders of the High Court starting at page number 30 at Annexure series.
Annexure?
Annexure 5 series, page 30, it starts, your lordship.
30. Yes. Yes.
My lord, know where the High Court says there are 3 orders of this Honorable Court. The matter is currently sub judice. The High Court has never ever said that you incorporate 109.
Where is the principal order?
The first order, your lordship, the impugned order, Annexure 1.
Principal order by which the High Court has directed.
High Court has not directed is my submission, your lordship. The High Court has not directed anything. It is an erroneous interpretation to the investigating officer. It is an erroneous order, your lordship, erroneous application. I have annexed all the 3 orders which they have referred to in the application at page 34.
Let us see the impugned order.
My lord, Annexure 1.
Yes. What does it do? Yes.
The case record is put up today for order on petition filed by IIC does for reopening of the case for collection of further evidence and incorporating section 109 of BNS for the interest of prosecution and in the interest of justice. My lord, may I just pause you for a minute? My lord, without further investigation, once the charge sheet has been submitted and cognizance has already been taken, my lord, this is already.
What happened initially in the PS case number 231, the police has already filed the charge sheet. Thereafter, the informed approach to the Honorable Court under section 227, read with section 482 of CRP, Your Lordship. This Honorable coordinate bench is
No, you
directed
just-
at a direction.
No, no, you
Lordship,
just
that's
answer.
right. I'm Lordship.
1 minute, you answer me. After investigation, the offense is decided or before investigation?
That's right, Your Lordship. Before Your Lordship. Filing.
Before.
Lordship.
Before investigation, offense is
No,
decided.
Lord, after investigation, Lordship, before filing this. Lordship, what happened?
You decided 109, I have to
What
incorporate.
happened?
And then you proceed.
What happened, Your
First you
Lordship?
investigate, get the material.
There is the file charge sheet, Your Lordship. That is there, Your Lordship. I am not disputing, Your Lordship. What happened? By the direction of the Honorable High Court and
Where is the direction?
But the law and trial court is clearly mentioned. Lordship, that is
Forget about trial court. Show me the order. Where that the court, this High Court says that in order to incorporate this particular section, investigate.
Yes, sir. That's
How
right.
can that be an order? First you investigate. If offense is made out, you include. It may not be 109, it may be 302 or 376, whatever. So can you decide a particular offense before investigation? 173(8) is not meant for that.
Yes, that I'm not Your Lordship. But what happened? The
Aiming to incorporate particular section.
Well, this is nothing but malicious prosecution, Your Lordship.
That's why that part I have obtained instruction how the after the filing
Not
and the
instruction,
charge sheet
this is
keeping
question.
without
This
keeping
is
open
a legal
investigation.
issue. This is
Your
a legal
Lordship,
issue.
that I have.
I'll issue notice.
Yes, Your
Let's
Lordship.
check it up. Huh?
Yes, yes, Your Lordship. Yes.
But I can't say further.
My lord, we'll file an application, my lord, because only cognizance has been taken in this last
But I
month.
can't investigate.
My lord, we'll file an.
Let us see what are the
My
materials.
lord, they
I
will.
may say that 109 is not made out. That's a different story.
Yes, that.
But I may simply issue notice.
My lord, I'll just pray before your lordship that I will file an application for adjournment that has to be considered.
Investigation, what adjournment?
No, investigation, my lord, has to be stayed. My lord, this is a malicious prosecution. My lord, this is malicious prosecution, your lordship.
Let the material come.
My lord, on the face of the
Yeah,
records.
after the material comes, then
Your lordship, on the
109
face of
will be
the records.
incorporated. I'll say that no 109.
My lord, on the face of the
But
records, your lordship is
investigation
seen.
can't be stayed, you know that.
My lord, investigation is being made out to include 109.
Simply-
My lord, in the trial court below, my lord, will file an application because the case is also proceeding.
Are you agreed by the
No, we are not.
173(8) or?
No, we are agreed by
It's
173.
already come and record.
No, 173.8, your
Then
lordship.
how can I stay like this?
My lord, your lordship is already seeing that on the face of the records. My lord, I would not have made this prayer but because this is malicious
You are
prosecution, nothing.
technically, made out a case, but
My lord, this is malicious prosecution against me.
how it's malicious?
My lord,
You are agreed by 109 likely to come.
no, they have made a mind that we will. The court has allowed that.
Take the mind.
Yes, that is the
Mind,
application.
you got the chips from the.
My lord, that is what they say, your
What are you
lordship.
talking?
My lord, would kindly say that is what they
Where
say.
is the material?
Sentence, and it is
Are you
absolute.
suggesting that the investigation is already over?
My lord, they will include this, my lord.
No, they will not. You show me. I'll quash it. Straight I will quash it.
My lord, may kindly read the last sentence, my lord. I'll not say anything more. I'll
I
just
don't
leave it
know
to your
whether
lordship.
merely it is handwritten.
Yes, that is even more. That is even more problematic that they will do this.
So that you are saying that since it is handwritten, the
intent is
I was made up his mind.
Yes, absolutely, your
Let
lordship.
him file and quash it.
I'll bow down, your
I'm
lordship.
saying it's you can't make up your mind and start investigating things. Okay. And 109, even if he that is on the basis of material.
My
What
lord,
material is collecting? Let us see.
my lord, now the charge sheet has been submitted. The report of the SCB
Let us
doctor
see
is
what,
there.
let us see what material he is bringing on record. Then we'll quash it. Yes. Okay.
In that event, my lord, in that event, since
But see, this is a legal issue. I'll tell you. He can't do that.
But Your Lordship, there is
Two mistakes. Two mistakes. He says that High Court has asked me.
Yes, that is
High Court has never asked.
that is there.
And
I'll verify the
thereafter,
out of the
he writes and to incorporate.
that handwritten, Your Lordship.
How can you say that I will incorporate without investigating?
That,
He has not even started investigation, and he says that in order to incorporate, I am investigating. How can he do that?
That's better.
Yes.
I'll bow down. My lord, may I make a prayer that in the trial court we will file an application
That
for
trial is altogether different for the offences for which you are not making any grievance.
I bow down, your lordship.
You are
I'll
not
put it.
making any grievance about that.
I'll leave it to your lordship.
Yes.
20. May I please, your lordship? This petitioner is a headmaster of a school. Your lordship has filed this case for questioning of criminal proceeding. Your lordship is to see what is the material against this case. That is your lordship. I have given attached all this. Lordship is to see at the time of occurrence where he was there and the ganja which recovered, whether that is conscious possession, physically or mentally, that is your lordship, because ROR I have given that land is not recorded in my name, that is recorded in name of my father. We have two brothers. Then your lordship is to see at the time of occurrence, I was 55 kilometers away from that place because I was discharging my duty. I have given that attendance register, your lordship. And
for the purpose of conscious position,
my lord,
always you should be present.
my lord, that is what your lordship is to see prima facie, your lordship. That is
Suppose you keep it in your house, you may be here. Recovery might take place.
Your lordship, the roof of my house, your lordship, that is they say, but that house, your lordship, that is a joint family property. And my brother.
At this stage, how can I decipher all these things?
No, your lordship, what happens for that reason, your lordship, I have brought one decision that
Yes.
I will cooperate in the investigation. But the thing is that the interim protection, no coercive step against me because I am a headmaster of the school. And the reason is that last election, I was secretary of the village committee. One party.
Why don't you have the other remedy? Why are you not applying for that remedy?
Your lordship, for that.
What I'll do is I'll simply issue notice and refer to the remedy.
Alternate,
I'll simply issue notice.
already approached the Honorable Court under Section 438 for bail, pre-arrest bail. This coordinated bench are not inclined, according to the petitioner seeks for withdrawal of the bail application. According to withdrawal.
I'm not suppressed.
That's
No,
right,
I'm
but
not saying your lordship.
see, it's not a case for question.
Yes.
In
But
any,
your prime of your lordship.
and you also know that. So you attempted, then you came to the right relief.
Your lordship.
But what can I do? The best what I can do is I can
So there
simply
is
issue notice.
prime of no material. That is in the.
See, this at this stage, how can I see this? It's a
But only
NDPS
I
case.
have apprehension of interim protection because of.
You have already burned your finger by approaching this court. What to do? How can I supersede that order?
Your lordship may-
What I can do is I can simply issue notice
My lord.
and you get fresh ground for approaching 438 court once again. Change circumstances.
My
Okay.
lord.
I'll just simply issue notice. And this could be a ground for, ultimately after getting that relief, I will dismiss it, but away till then. Okay. Yes.
In this application, my lord, the petitioner challenges the order dated, my lord, 12/2/2025, my lord.
Yes.
But this is OCC case 138 N Act, my lord. After receipt of the summons, the petitioner filed an application under section 205 of CRBC that has been rejected, my lord. Your lordship kindly glance to the,
205.
my lord.
Although as and when you appear and I'll allow this. Yes, sir. Right now. Petition is agreed by the order dated. You have not filed anything. When the
12/2/2025.
2012, 2024.
25, my lord.
Page 9, your lordship, start 12/2/2025, the impugned order, your lordship.
No. Complaint filed. When?
Complaint file, your lordship, 11/7/2024.
24.
Yes, your lordship. 121/2020.
Except impugned order, you have not filed anything.
No, my lord, I have filed the OCC case.
Where is
Page
the
11, my lord.
11, your lordship.
Where is the complaint?
My lord, page 11, my lord.
11. Okay. Yes, 2024.
My lord.
Right. Petition is agreed by the order dated 12/2/2025 passed by the JMFC
Soro.
in 1CC case number 121 of 2024 initiated by opposite party number 2 against the petitioner for alleged commission of 138 NIA, whereby the application of the petitioner under section 205 CRPC has been rejected. You have already appeared? You have first, once also you have not appeared.
No, my lord.
Once you have to appear, you can take the bail. Okay. Then only to you. Then
Bail I think so, sir.
you commit the crime, your lawyer will go and face you.
My lord, 205, my lord.
Once you go and take the bail, thereafter 205. Okay. I don't. The counsel for the petitioner fairly submits that after receiving the summons from the court, he is not, the petitioner has not appeared in the court and then to pay. However, he moved an application under 205 CRPC, which has been turned down. Needless to say that persons to be summoning order petitioner to appear before the court and seek grant of bail from the court below. Thereafter, he is entitled to move application under section 205 CRPC. When are you going to appear? 30th April?
My lord.
Counsel for the petitioner on instruction submits that the client would be appearing before the court on or before 30th of April and the short to the remedy and subsequent to the appearing before the court, the liberty is granted to the petitioner to move application, a press application under 205 CRPC. If such application is done, the same shall be considered, keeping in view, same shall be considered on its merit. Needless to say that the petitioner, in cases of appropriate petitioner can appear through the counsel or video conferencing mode. However, as and when the physical presence is required, he has to appear in the court. This observation petitioner disputed. Yes. Yes.
There is a case, the petitioner praying for quashment of the entire proceeding. Petitioner is the absconder and the court against him, the case has already been split off. Court is acquitted on the grounds of co-accused acquitted, present petitioner 6 for quashment, offense 302, and present petitioner the FIR name accused, your lordship.
Password?
Yes, your lordship. Yes.
23.
The order of taking cognizance, it on, but the complainant and the petitioner are lecturer of a college.
Complainant and
Petitioner.
okay.
There are chances of compromise, your lordship.
What are the offenses?
354, man.
What have you done?
That is, there's earlier one FIR also lodged by the
Allegation is the repeated sexual harassment.
Harassment.
kindly see my lord, page 20, Annex 2.
Harassment in the workplace. No inquiry.
Kindly see page 20, my lord.
20. 20.
To Annex 2. There was compromise earlier.
Even after compromise, again you are doing the same thing.
There was a tussle about the between the petitioner and complainant through because of power, my lord. The principal, the petitioner was in charge
What power?
the petitioner was
You are a
in charge
lecturer, what power?
and the complainant is next to the
And she is 54, you are 52. Is the right of issue. Settling the dispute unnecessarily. You see in the.
It can be settled.
What are you teaching to the student, both of you? You yourself in the indulging in 354 and all.
Outside.
What kind
The
of
Odia lecturer and the petitioner is the
History.
Sanskrit.
Sanskrit lecture? Very good. Issue okay. Settle the dispute unnecessary.
May I pray, my lord? IA.
What IA for the?
Pray of further.
I can send it to mediation.
Yes, my lord. Your lordship may send.
Where is that 24th? No? I think 23rd. I'll send it straight away, send to mediation
My lord.
and settle it up.
My lord.
Necessary FIR put rokelo. Tangi.
FIR page 13. my lord.
Kotak, huh? Kotak district.
Yes.
center?
Yes.
High Court
mediation.
High Court mediation.
Yes.
High Court mediation. High Court mediation notice karo. Tapore liberty to move up into going to the fact that matter is referred to mediation after 2 years.
Till then, further proceeding next year. Obliged.
24.
Offense. 493, 453 Act. Present petitioner
Okay.
के मामू माई माई
Issue note.
related.
Issue note. Yes. Issue note. Matter in yes. Next. 25.
My lord, petitioner regarding the route la. FIR laws, just Suna Beda, 500 kilometers.
Let us see, let them come, we'll settle it.
This is my lord, in appearing stage.
It's all right. Application.
That is also matrimonial.
Next matter is also matrimonial.
Then I put a residence related.
You don't want.
And to appear, appearing there maybe.
I have said there, why I know the matrimonial dispute, more they'll come to the court, more hostility develops. So it's better that don't go to the court. Finish it up before going to the court. That's what
Distance related.
I know that, I have done it. See, 20?
25. Matrimony
25
disputes
also
also.
same photo.
Unless there's an IA to stay the proceeding in the.
Yes, my lord.
26.
26 we are going to delay
Okay, on behalf of the counsel for the petitioner, Mr. Boi, adjournment is sought. Yes.
27. 27.
Private dispute.
Private, okay, password.
28.
Item number 28. I'm praying for short adjournment. Maybe day after tomorrow, Thursday or Friday.
He has prayed for early disposal of the.
What I prayed for, I am submitting. It is better, Lordship may take it on day after tomorrow.
1 minute.
Day after Thursday or Friday. My long train is.
What do you want? You tell me. If possible, I can allow it right now. That's
Yes.
what I'm saying.
Okay. Only thing
If
is
any
that.
problem, I'll.
No. Yes, I'm blessing.
Yeah. If the prayer is genuine prayer, then I'll allow.
I have a genuine prayer.
What do you want?
Annexure 1, Lordship, page 23 is the petition filed by the petitioner. That is 144 CRPC for imposition of 144 CRPC. That is filed before the executive magistrate nearly. That has been filed on
2023.
Annexure 1, page 23.
You filed in 2023.
I have filed in 2023. But what happened, my lord? Lordship may see. That is, Lordship may straight away come to annexure page 27.
Yes.
After the petition has been filed, the direction was issued by the Tahsildar to the concerned police station as well as the RI that please kindly inquire into the matter and submit the report.
Yes.
Lordship, page 27 annexure to last towards the bottom. Lordship may see. But the second party members blocked the disputed land. Hence, there is every possibility of apprehension of serious breach of peace in the locality, which will lead to serious rioting, arson, and bloodshed in near future. Therefore, it is prayed that a RI or admin may kindly be deputed for identification and demarcation of the dispute. That is the police report. After this police report, promptly the executive magistrate should have acted and imposed the 144 CRPC. What he has not done so till date. And Lordship may see the next is next is much important because the land belongs to me and the RI report is also in my favor. My grievance is that the petitioner who is working in SESU, he is an executive of the rank of the AGM. He is a finance officer, cost accountant. He is unable to move to his own land because every time he is going, there is a apprehension of bloodshed.
I'll issue notice, let him come.
Lordship may, what I am proposing, my lord, instead of keeping the matter pending, Lordship may direct that Lordship may state last submission, my lord, annexure 4, that is the order passed by the Tahsildar.
Yes.
Although the petition has been filed under annexure 1 since 2023, he is sitting over the matter. It is statutory.
Direction to dispose of.
Yes, disposed of and restore the peace and normalcy. To ensure the peace and normalcy.
Peace and normalcy, you will do it.
Lordship is
only
Lordship is
give a
only
direction to the magistrate to.
Lordship is omnipotent, my lord.
No, peace and tranquility you have to maintain. You and second party.
My lord,
No court, no executive magistrate can.
it is the obligation of the state to maintain the peace and
And
tranquility.
you keep on fighting, then why should?
Sir, good sentence. Sir, he is my friend and he is making my submission.
I'll dispose it.
Yes,
Right.
Lordship may add one sentence, my lord.
I know petitioner on they say what is the date of this first your application on 5/2/23 moved an application before the executive magistrate being criminal miss case number 251 of 2023 under section 144(2) of CRPC implementing the opposite party. Second party. the executive magistrate sought for a report and on 15/12/2020 is on record by the SI nearly inter alia stating as an it 2073 last three lines. However, the same case finally dismissed. So the first party mutated the last one. Pursuant to the said report, the executive magistrate by order dated 6/12/2023, although directed the second party to appear before the court, second party or the opposite party number 2 to appear before him on 16/12/2020. However, no action has been taken, and the dispute is still prolonging to be adjudicated. At this stage, the petitioner has approached the court by filing the present petition, seeking a direction to the executive magistrate nearly to dispose of the criminal miss case number 251 of 2023. He has initiated, the petitioner has initiated on 2023. The prayer made by the petitioner seems genuine and innocent. Hence, the same is allowed. The executive magistrate merely is directed to dispose of the criminal misdemeanor so and so within as early as possible, preferably within a period of 1 month. Hence,
with Lordship's permission, I supplement only one thing, that prevention of breach.
I can't make any.
Only one sentence. Only one sentence.
See, I'll tell you. I can't make any.
Milord, Lordship has passed a great order. What Lordship may allow only one sentence. At para 18, I have cited so many case laws, and that is the.
I will not say a single word regarding the merits of the case.
Milord, it is obligatory.
See, one word sent observation also will create problem. But then I will have to issue notice the other side, and all these things have to. If I make a single sentence regarding merit, then
What I am saying, Milord, para 18 have summarized and catalogued.
It is open for the petitioner to or all other points which has been raised by the petitioner before the executive.
Yes. Great.
Yes. 27, my lord. Yes, 27. You has come. Yes, sir.
My lord, here I have prayed for quashing of the entire DV proceeding filed by the wife, opposite partner 1, my lord. Well, the marriage was solemnized on 12/5.
Okay.
And the wife left the matrimonial house on the 28/3/2018, my lord. Thereafter, she filed a proceeding under section 125 CRPs for maintenance, and 10,000 was granted. Subsequently, this honorable court in the revision, my lord, it became 15,000 per month. I filed a petition for divorce, and that due to the compromise, I withdrew the divorce proceeding for union, and she without union.
There is no 498 and all.
498 and there is no. Your lordship, kindly see, I filed a petition for restitution of conjugal rights. What please the wife has taken in the proceeding, that was taken in the.
What is she asking in this proceeding?
For quashing up the DV proceeding, my lord.
What is she is asking in this?
She is asking, my lord, under Annex 1, I have filed the petition. She is asking for compensation of 60,000 rupees. 60 lakhs rupees.
Let us see the prayer.
43.
Page 29.
At page 27, my prayer, my lord.
27.
Order required, my
Yes,
lord.
27, order required.
The respondent be prohibited committing any act, my lord, 27 page.
Yes, I am there.
Respondent be any act of domestic violence against the agreed person. But she is staying.
Is there any chance of settlement?
No, there is no chance of settlement. The settlement, I filed the restriction of conjugal rights, my lord, she did not come. Your lordship, kindly the finding, my lord. Simply, what plea has taken, your lordship kindly come to.
No, what is the order passed in this?
Restriction of conjugal rights, my
No, no, in this proceeding,
proceeding is going on.
there is no order passed.
No order passed. Only that the 10,000 my lord, that.
Have you
petition-
filed your so called
Yes, my lord.
reply you have filed?
Yes.
Filed.
There, yes, my lord, I filed the reply.
Where is your reply?
The reply I have not given, my lord. You will also kindly come to that plea what she has taken, page 36, kindly see, my lord.
36. Yes.
Yes, 36 the issue, my lord. Keep tied to that, my lord. I have taken that summarized by the
Yes.
family court. My lord, paragraph 8, page 39, my lord.
Yes.
The respondent in her pleadings and evidence has taken the stand that by suppressing the fact that he is mentally disturbed husband, present petitioner, and has been under long mental treatment before marriage, the petitioner and his family have practiced deceit and treachery on her and her family.
Okay, I'll issue notice. Let us see. There are a lot of disputes.
No, that
What will happen with this degree?
decree nothing. She has not come.
He will not come.
He will not come.
The type of allegations.
And this is not the Lawrence family judge has held that there is no cruelty at all on the family. So much she has left.
Okay, issue notice to opposite party number 2. Opposite meantime, petitioner is at liberty to move application for the High Court seeking an adjournment owing to the fact that the matter is before this court. Yes.
Interim application.
I passed the
For the clear.
29.
Lordship, item 29, Lordship, kindly be passed over, Lordship.
Pass over. Okay. Deep.
30, may I please your lordship? With this LLC filed for questioning of the cognizance on the ground of settlement, my lord. The matter arises out of there is a quarrel between Mobus driver and the passenger, my lord.
Yes.
Uh,
How is that?
my lord, there is 4 charge sheeted accused persons.
You have included only one.
My lord, the complainant want to compromise with the
Complainant chooses to settle the dispute through you. Why you?
My lord, this present petition I am fairly submitting. He is selected for the post of constable in Odisha Police. And due to
I am for the informant, madam. My name is not there.
So your name will be reflecting, but you are
I'm driver of
settling
the-
the dispute prisoner only. What about
Yes.
the other?
Only nine, Janak Pankaj.
only for this present.
Accused person 4. I am the driver of the bus.
No, there are 4, 5 accused persons, 34 and all are there. So are you settling the dispute with all of them or settling the dispute with him only?
Only one.
Why have you chosen her? Why not others? You settle the dispute, will settle the dispute with all accused. You can't choose one.
D07 is there.
With that's the problem. Who is the injured? Injured in this case?
My lord, the complainant, the
Complainant.
driver.
So issue notice to opposite party number 2. They shall accept notice for this case. And the so and so and said appearance on advance notice and please to file whatever. Yes.
And 31. My lord, OP2 already entered already filed their wakalat nama.
I have said yes. Yes, next.
31.
May I please lordship? My lord, I'm simply praying before my lordship that first star, second star may be given.
Sorry,
I'm simply praying my lord first star, second star in this challenge.
I didn't follow.
Second,
No, what is this? Quashing?
Passing, but
Your anticipated bail rejected.
3 times.
Where is that order?
Orders I have not, I'm in the certificate portion. I have given all the
Show me the order at least.
orders I have not print carding.
If you want some order here, which may, overlap the order which has already been passed.
That were rejected.
Pass over,
That were rejected.
pass over, pass over.
And
Come with that order.
matrimonial dispute.
30? Yes. Yes.
Challenges the order dated.
498, eh? Is notice. Is notice? Yes. Yes. 33.
33.
Here the petitioner, my lords, with a teacher at the Interim Vidyalaya, my lords, has assailed an order against him, bringing charges on 341, 354, 354 A and B, and 8 and 12 of the POCSO Act. Order framing charge is at annexure 1.
Yes.
A petition for discharge was rejected and charge has been framed. Paragraph page 17, my lords.
Yes. Yes.
He says that last paragraph. While going through the present petition, I am restrained to not weigh the evidence in totality. The court has to see whether there is sufficient ground to proceed against the accused, provided by materials available on record and prima facie material to proceed. In this case, at the plea of the accused petitioner regarding sexual intent has not been proved in the present case, which has to stand the test of trial. Same cannot be to discharge the accused. As such, having absolute regard to the presumption of innocence of the accused, I am not inclined to consider the same at this stage in view of.
Where is 164 statement?
They have not filed, my.
Huh?
Not filed, my.
You have?
No, my lordship. The press admission, my lordship, notice to be issued and call for the.
Get the 164,
Yes.
whether 164 is recorded?
Must have been.
Must have been recorded. 161, do you have?
161.
Victims.
No, my lordship.
Whether POCSO, this man is a teacher.
Yes, my lordship. It's the principal of.
Principal.
Yes. And she is victim is a student, my lordship.
You get it, I will not issue notice Friday.
Yes, my lordship.
Friday. If it is there, then I will see.
Yes.
Otherwise, Friday.
Friday.
Get that 164 statement. Okay. Yes. If not 164, if you don't have, then at least 161 something you
Yes.
see. He may not be having that. Yes.
34, my lord, may I please your lordship? My lord, in this case, the petitioner challenges the entire criminal proceeding.
Friday matter ko, eta ko 15 ko. 15, yes. Yes.
May I please? Well, the petitioner challenges the entire criminal proceeding, more particularly annexure 2, my lord, the order taking cognizance. If your lordship sees the order taking cognizance for a moment, my lord, that is at page.
Yes.
Page 20, my lord. Sorry,
20?
page 36.
36, yes. Yes. Yes.
My lord.
I'm there already.
47 is.
What is your case?
Lord, my case is that I have challenged this essentially on 4 grounds, my lords. Number 1 is the order taking cognizance has been passed mechanically without jurisdiction, my lord. The learned magistrate has assumed jurisdiction which was not conferred upon it. Number 2 is the opposite party number 2, that is the police officer. He did not have the authority to investigate into the offences under the Food Safety and Standards Act, my lord. And FIR has been lodged against me for the offence under section 420, which I humbly say, my lord, reading the complaint or the FIR as a whole, my lord, 420 is not made out. These are the 4 grounds which I am assailing. Now, if your lordship sees annexed, the magistrate has taken cognizance of offences.
Where is the charge sheet?
My charge sheet is at page 35.
30?
35.
Charge sheet filing.
Charge sheet है
No.
FIR and charge sheet both have been filed.
Where is that?
And charge sheet.
Cognizance order that has to be there.
Cognizance order is there.
That's right, but I need to know what are the allegation.
I'll just check up, man. I'll just check.
No. You file it. Then counsel for the petitioner seeks to place on record the copy of the charge sheet in the present case. As the sale in the order dated 5/9/2024, whereby the cognizance of offences punishable under section 37 and so has been taken against him by JMFC bracket GT Cutter. Please the matter after 1 week. Yes. After 1 week, you place on record the other documents. And, yes. Yes.
2/8/2023 petition has been released on bail, my lord. And 25/3/2025 warrant, my lord, NBW show.
Yes. Yes.
The petition was on bail on 9/4/2024 and NBW was issued on 20/1/2025.
39.
Bail on 25/1/2019 and NBW on 5/7/2024.
40.
Bail
order is on 14/1/2006 and NBW issued on 24/6/24.
24?
24/6/24.
41.
In this case, the plaintiff petitioner has filed this case against the order of rejection of his recall petition filed to recall the Amin Commissioner for further cross-examination.
Recall?
The Amin Commissioner for his further cross-examination.
Which is that order? Show me the order.
That is under Annexure 8, page 40.
First time this matter is coming up?
Hello? It was dismissed for default. My name was written Bhubuti, so I missed the list.
This was dismissed?
It was dismissed for default, thereafter restored.
Okay.
Due to wrong spelling of my name.
Yes, madam.
Lordship, in this case, we after two cabinet petition and here in this case petitioner soft copy. Tomorrow we receive soft copy through WhatsApp, and in this case, in both the both in civil suit matter is pending 2010 in Pipil Judge, sorry, first was civil judge senior division Pipil. And in both district judge as well as in civil judge senior division through FAO, we win in both the cases. FAO 2/2020 before the first additional district judge Puri and in civil judge senior division Pipilios. Plaintiff in IL Lordship. So in this case, I pray as if the stay order is granted by your lordship, then there is a loss because that the suit matter is pending before 2010 and evidence yet has not been started. Only suit is admitted. So
Then what do you want?
Lordship, I pray for 1 week time. Lordship.
I'll put it next week.
Put it on 16th.
16th.
Date may be fixed.
16th, I'll put it on 16th, okay?
My lord.
Yeah.
Youngster. 16th. Just come. And just
Coming up charge. I'll file the charge sheet copy, my lord. Next week, my lord.
It's 1 week time to file copy of charge sheet, yes.
Please, your lordship, my lord. The matter was earlier disposed of by the order dated 4/8. If your lordship will be at
4/8.
4/8.
8/4.
8/4/2023. Well, your lordship may kindly have a glance to para 14 of your lordship's judgment.
Para 14.
I have prayed for modification to the extent that at para 14, your lordship has said that the trial shall proceed at its own pace. However, no final order will be passed until the Honorable Apex
final
Court
order.
decides the matter. Now the trial is at the fag end. My lord's judgment is to be delivered. Therefore, I am praying for modification in view of the fact that
What have I said?
well, here
Uh,
this RLMC
final
was
order.
initially filed because the chemical examination report was not on record when cognizance was taken, for which your lordship had delivered the judgment.
Yes, awaiting more.
Awaiting, my lord, clarification to the extent that since the trial has already reached its fag end, my lords, only judgment is left to be delivered, and the evidence has to the fact been to my benefit. I'm praying for modification to the extent that
That means you know that you will be acquitted.
because I have strong belief now.
How do you know before the judgment is pronounced?
Well, it's the witnesses, independent witnesses have not supported. Well, it's a case of NDPS.
I have only said that since chemical analysis report is not there on record, so that matter to a large
That is still
extent,
pending, my lords.
let it be decided. Thereafter, your final judgment will be
My lords,
pronounced. You are on bail already.
No, my lords, I'm not on bail. That is my predicament. I'm
You're
not
not on
on
bail.
bail. The matter issues commercial quantity, therefore. Almost 1 kg of contraband brown sugar.
What do you say?
I ate a file.
We have not, no copy.
How actually Binha copy is file only again.
Give a copy, extra copy. Huh?
Well, let it come tomorrow. I will give a copy.
I'll put it on 16th. 16th. Okay.
16.
I will copy.
Thank you. It's over. A copy of the IM, my lords.
16th. Okay.
44. এটা হচ্ছে রিসিপ্ট এটা দেখতে না সেইটা দিব রিসিপ্টটা দেখতে দিব দেখতে দিব তো মগি
Yes.
44
Service देखो.
Okay to not to use appeal. Notice not sufficient. Without instruction. Without instruction. Not appeal. Not appeal.
Not appearing. Let us see who is appearing for petitioner. Okay. Pass out.
45.
45 plus extension of date of surrender.
45.
Date extension of date of surrender.
Extension of time for
4 weeks. Plus.
extension of time for surrendering. For the reasons stated. It's made clear that no further extension. Yes.
Okay.
46.
May I please your lordships? As per the order of the Honorable Court, on 3/2/2025, this petitioner deposited 20% of the check amount and also filed the requisite for the opposite parties. And this petitioner challenged the order of the cognizance of offence under section 138 of the NI Act dated on
1 minute service.
Late
You have filed this lately. You have to file the service on opposite party number 2 could not be completed due to late filing of the requisites. The requisites already filed be utilized for the purpose of serving so on. Yes.
47.
The petitioner approached the Honorable Court questioning the entire proceeding to the compromise. The both parties are present.
Well, I am appearing for the court, my lord.
What are the offences? What are the offences?
Already the matter has already been compromised between us and we don't want to.
What are the offences I am asking?
My lord.
294.
Where is the charge sheet?
Already
294.
filed on the.
My lord. Hold on.
How many accused are there?
One, two, my lord.
Nice.
One or two.
Total how many accused?
Four number of accused person. And the petitioner one is the husband and two is the mother-in-law.
Informant is present, my lord.
There are four accused persons.
That's
You have filed like for two. What about the
I filed the two husband and mother-in-law. And the total of
what about the other accused persons?
you can say file for ଦି ଜଣ ଆସ
Have to bring them. Don't file documents.
Family also. Sister-in-law.
Yeah, what do you say? The other accused persons are not there, neither implicated, nothing is there.
My lord.
Just see the charge sheet which you have filed. So place this charge sheet on record. The counsel for the petitioner seeks. Then please on record the copy of the charge sheet. Yes, let him do so within a week. File the charge sheet and the other accused persons also you implead.
My lord, my lord.
Then only it can be quashed.
My lord, my lord.
I'll quash it, don't worry.
Yes, sir.
Vocal. Don't to enter a period
My
from
name
the
is-
opposite party. And vocal. Yes. Yes, next.
Eight.
Okay. Issue notice. 498, no? Issue notice to opposite party.
49.
Lordship 49, Lordship. Requisite has already been filed, Lordship.
Huh?
Requisite already been filed.
Late file.
Late file requisites, huh? To be utilized. Yes.
Deeply.
50.
Item 50, my lord, notice return from the opposite party to my lord.
Hmm.
On our fault, my lord, we have wrongly mentioned the father's name of the opposite party to my lord. Are we allowed to file correct court title and fresh notice? My lord?
Mr.
Correctors.
Takes 2 weeks, 1 week time. Huh?
1 week
time to file corrected copy of corrected the
First
court
title
title
and also
of
the correct answers.
opposite party and take necessary steps to serve the opposite party.
Obliged.
51.
This is application for modification. Your lordship may turn to order dated 17/2.
Yes. What modification?
Para 8. Your
Yes.
lordship mentioned trial court. This is a case which was cognizance were taken on basis of a complaint petition and pending before the Marital court. So in place of trial court, your lordship may mention the court name and with
The liberty is granted to the petitioner to urge all the points before the trial court.
the trial court.
In case of trial court, you want the trial court's name.
Case number
Trial court.
on event, he will approach the higher court on the same day because this is a case on section 302.
Clearly available on the court. No court action shall be taken to the petitioner.
ରଖିଛନ୍ତି ସେଟାକୁ on event
Courts below the however the remedy will be cancelled. Surrendering resort to the remedy available to Marital, liberty is granted to the petitioner to urge all points. We are proceeding.
ଖାଲି ସେଟାକୁ JMFC
Courts below.
ଆଜ୍ଞା.
My lord, I am appearing for the complaint in this case.
Huh.
My appearance may kindly be noted.
Yes.
And
Courts below. For the reasons stated in the application, the same is allowed. Para 8 of the order dated 17 to 2020 5 is modified. To the extent that the liberty is granted to the petitioner to urge all the points before the court of
JMFC 4.
Bail application. Trial court, which trial court you are talking about? Give the trial court name.
Trial court nahi, se committal court re achi.
The two courts below I have written then, both the courts.
Se buji paribene, the specific নহলে. Magistrate মানে
Plural, this is a plural courts.
কোর্স বিলো মু পড়িছি সে কোর্স বিলো থাও সে খালি সে সরেন্ডর করি ফার্স্ট হাফ রে সেকেন্ড হাফ আজকাল তাঙ্কর বুঝিবা টিকে কম হেই যাଉଛି বুঝি
That to the petitioner is at liberty to surrender and move application for grant of bail. The same shall be considered by the court of JMFC 4, Cuttack. Cuttack, in the event of the rejection of the bail application, the application to be moved by the petitioner before which court the sessions shall also be considered on the same day.
Parity member. So what happened? The co-accused has already been parity, if any.
Mr. Mahapatra further submits that the co-accused persons, since the co-accused persons have already been enlarged on bail, he is entitled to parity. Petitioner is at liberty to raise this point before the court. Yes.
My lord, one thing, what happened actually, modification was filed before the date Hon'Ble court. That was 30th.
Extension, 30th.
1 week time.
30th for the reason as stated above, the time granted to the petitioner to surrender before the court 30th March is extended up to 30th April. 30th April.
My lord, one thing, I take leave of this Hon'Ble court.
That's the problem when in a modification application, when senior appears, this happens. Slowly. At the end of the day, when I read the order, I'll grant you bail. I'll read then. Slowly you are asking one after another, aiding. That's the and this is good that these people should learn.
Item number
how to get the order.
More persistent.
How to get the order one after another.
Item number 14, the order has been given to my friend, and the same order was passed. Surrender available. That is anticipated.
You come at 2 o'clock. Please do it. Yes. देखिए दो बेटा ऑर्डर okay.
Sir, application for closing of the charge also the proceeding my lord. Because of the FOXO notice has been issued. Today is fixed my lord. So
service is
Neither ready nor unsolved notice return.
awaiting service or opposite party. This is the matter of 1 week. Yes.
I pray one thing, my lord. The case is now proceeding, and the 10th is fixed for the trial, my lord. And I pray one thing, lord. If time petition will file, then only for that. Because it is not a case of POXO. At the age of 26, he filed the application, and also if he gone to the annexure 2 in 2020, filed one FIR that is 354. But another FIR on 2021 that is 554.
Why the service is
It is in transit.
Let's see, it is in transit. First day I didn't pass the order, means there must be something. Let it be on 17th. 17th. Yeah?
10th is date for that is a
what is going to happen?
দুইরে থিলা পন 10 কো
Are you going to be hanged on that day? What is going to happen?
only time petition
thereafter it will never come. That's the problem, I know. So therefore 17th you come, if it is to be quashed, I'll quash that day. Because it is in transit, the notice is in transit. He will receive.
16th.
16th, okay. 16th. Okay.
53, my pleasure.
This challenge, this case order dated 10/9/2024 for a rejecting discharge application. Or there are delay of 28 days as because the petition wrongly.
Forget about it. Yes.
And this decision, my lord, the entire case covered by your lordship judgment, my lord.
If a lordship
Judgment passing there.
may not be required, lordship can say, bear me, lords. My submission will serve the interest, the ends of justice for all the parties. This is a judgment where it is distinguishable with the factual scenario in both that case, in this particular case, and had lord. But if a lordship turn to page 92 of a lordship brief, lords, that is interest, 92 of the brief.
Whatever I said
In that judgment, my lords, two persons have the same name, same age, same father's name, belong to the same residence, my lord. That scenario is not there. Here is a land acquisition officer. In our lordship, turn to 92, and that's subsidiary interest, my lord. 92 of the brief. Page 92, lordship got it, lords.
What is this?
Lordship, turn to paragraph 2, my lords.
So parentage, village, and everything was.
No. Here the land acquisition officer who issued that notices, my lords. And inadvertently gone to the wrong persons, my lords. The lordship to para 2, my lords. Lordship can see that last line of the para 2, my lords. The OSTGA department. So on the basis this can be disposed.
The refusal of the order of the there is no sanction why
so that judgment need not be placed.
Why are you reading it? There is no sanction.
No, since your lordship never had malady. Beautiful judgment, my lord. I have never seen this.
I agree. That's one of the judgment.
Most time I will read out your lordship judgment. I do not know whether this case came to me, my lord.
No, in fact, he's happy, my lords. I agree with you, my lord. I extend all
But in your case, there is no sanction.
But in this case, if you added, my lord, this judgment, my lord, the beautiful judgment, my lord.
No. That's a different scenario, my lord. Land acquisition officer cannot stand. They cannot stand on the persons who are being paid wrongly, my lords. In that case, when the accused was working at Bangalore, my lord, his family member inadvertently received that notice, saw that the same accused person named, this is the same thing, my lord. He was asked for and he received that, my lords. But subsequently, it was detected.
It's not granted. Why the trial court has not taken it?
In fact, my lords, my pardon.
Trial court has not taken into that.
In fact, you'll also turn to that chart sheet, my lords, at page 69, my lords.
69? Okay. 69. Okay.
His name was not there.
What is his name? He is.
And it was my lords. But by order dated, so when some lot that order was passed taking cognizance. Lords, you turn page 62, last line, lords.
62?
Page 62, lords.
Okay.
Last line, lords. It's after completion of investigation, charge sheet has been submitted for offense so and so, lord, against the accused person, excluding the present accused petition. Admittedly, government has been pleased not to issue sanction of prosecution against the present accused. Thereafter, my lords.
The options of sanction.
That's substantive interest.
And that this your judgment delivered judgment, but these are co-accused, my lord. In this present case, my lord. And there are 4 accused persons. One accused should be discharged, and another, my lord, this petitioner. 2 of the co-accused persons, they are amino, my lord. They have been expired in the meantime. Left only one.
May I suggest one thing? Today is listed for the orders for limitation. Lords, we dispose that works.
I will dispose of the main petition.
And on the basis of this.
I'll discharge it.
Lordship, because the judgment should not be placed to service. There is the ratio of that particular judgment.
That ratio, he is not relying upon ratio.
Different set of facts.
No, he is not relying upon it. What he says is there are 4 accused. 1 accused I have quashed. Okay. 2 accused have died, and this is accused, no sanction. No sanction.
That one line is absurd.
Only that ground. I will give for the reason stated in the application. The condemnation of the delay of 28 days in filing revision petition is allowed. Petitioner is agreed by the order dated 10/9/2024, whereby his application for discharge has been rejected. This is application for discharge
Discharge.
has been rejected.
Already
Therefore,
rejected.
he has preferred the revision petition. The Mr. Chandra. Mr. Raghunath, let us account for the petition submits that there were 4 accused persons. And against 4 accused persons, charge sheet has been filed in the present case for alleged offences under section 144. Out of them, 2 accused persons have expired during the
Page 22.
50?
Page 22 clarifies that.
Huh.
Page 22.
22.
1, 2 died.
Died, huh?
1, 2 died, my lord. 3 is discharged.
Yes.
And the 4th is at page 23. my lord.
Died on when?
1, 2, 1, 2.
No, when? During the
Pendency of the case.
pendency of
After charge sheet, my lord.
Okay. After the charge sheet was filed, 2 of the accused persons have page 22 who have already expired. Insofar as the other co-accused person, Arun Kumar Mahanti, is mentioned, is he preferred a revision petition against the charge, which has been the revision petition has been allowed by a detailed judgment dated 29/1/2025 in criminal revision 722 of 2024. The present petitioner is seeking relying upon the ratio laid down by this court in the case of Arun Kumar. Which paragraph you are relying upon? 16.
Yeah, lordship, could you question to me, lords? Which the judgment, my lord.
Feeling tempted to the money.
No, my lord.
Is a natural instinct of human being.
Never led support to his case, my lord. In fact, the petition of lordship issued
By the time
notice
he
only.
is the land actor officer, entire money refund by the
Relied upon page 16 and 17. The petitioner, the petitioner hearing, the land acquisition of
Land acquisition.
of and in fact, land acquisition officer.
One line and judgment may help him that the lordship findings that no financial loss.
At the outset, I have gone through the discharge application moved by the present petition. The para 3 of the third petition is important for the purpose of the present petition. We read said under Annex 492 para 3. 92 para 3. The piece on the thought that the competent authority has not for intention to prosecute to the present petitioner. The which paragraph you have shown me that or 62, na? The trial court.
Oh, please, my lord. Your lords may turn to page 92, my lords.
No. 62.
That charge sheet, my lord.
Yes.
Page 22, my
No,
lords. That's the person's names, my lord. And my lord, the charge sheet is at
the trial court, while dealing with the
68 months.
issue of sanction, has inter alia considered agenda in the implement. Page 62. Page 62 goes on the perusal of the case record. That's agree. Paragraph. Mr. For the availance in so far as the sanction issue of sanction not according to sanction to the petitioner is not able to dispute with the same. And therefore, in the present case, in the absence of proper sanction being granted by the competent authority to prosecute the petitioner, the trial courts ought not to have taken cognizance of the offence. Moreover, the co-accused person, the principal accused in the present case, has been discharged by the legal order dated from. Yet we have all the decisions made by the bar and inclined to allow the commission accordingly.
Paragraph 10 of my lord's judgment, my lord.
Para 10.
Para 10.
Para 10 of you.
No, actually, Mr. Das, not counsel for petitioner, Taking the admitted the fact present case and has submitted that out of 4 accused persons, two of them have already expired, and the petitioner and one nuisance and have been present petitioner. While facing trial. Clear is.
Okay.
Lordship may record the formal objection.
Objection, formal.
And my lord, sir, before Lordship permission, my lord friend is agree with me, my lords. This is one of the few judgment, my lords, where a lordship has poured out your lordship hearts.
Exactly. That's what I 4 times I have read.
Yes, commendable.
Same name, 2 persons. Others name same, everything same.
But see, this is human tendency of, getting tempted towards money. That is the reason I wanted to see the reaction of a person when money comes.
It's not this, my lord. When I went to them, my lord, your lordship compassion poured out, lords. Absolutely, my lord.
That is everybody get tempted.
Approaching in a pragmatic way the human tendencies, my lord, that what is we all human beings are susceptible to so many temptations.
Because of your assistance. That's the reason.
Also utilize your lordship experience while you are an advocate, my lord.
Thank you very much. Thank you. Yes. Junior counsel should read this to understand the nuances of law. Yes.
Your lordship, dispose of matter, order dated 2/4/25.
Yes.
Para number 4, it has been wrongly typed as District Bar Association Daspala instead of District Bar Association Noyagarh.
District Bar Association?
Daspala instead of District Bar Association Noyagarh.
Noyagarh. You want Noyagarh?
Yes, ma'am.
Instead of Dasapala. Dasapala.
Okay.
55.
Time, extension of time, you are not asking? Extension.
Your lordship?
You don't need extension.
No, ma'am.
25th April. 25th April. Yes.
55.
Take. 55.
56. 56, there is an application where the number 11 has died. That's a substitution. IA number 28 of 24.
OP number?
11.
11 died, huh?
11 has died.
LRs?
LR's notice had gone. Your lordship will see at flag item delivered. So it is to be treated as sufficient.
Notice sufficient, huh? Yes.
Well, now I'm ready with it.
Yes, you are appealing for?
OP number 4, my lord.
4. What about the other?
Others, Mr. Mahapatra is there for some of the parties.
Also.
Danan Mahapatra. Well, I'd hear very interesting.
He can't be now, he's senior counsel.
I pray for pass over, my lord.
Pass over.
Then it be some other bill.
So is it a big matter or small matter?
Very short. There was a suit appeal. Appeal remanded the matter. Directed for a commissioner to be measure the suit length. 2 commissioners' report was objected to by plaintiff. I am the plaintiff, as well as defendants, rejected. 3rd commissioner report, both plaintiff and defendants objected, and in the evidence, the commissioner says that he has not taken the 3 junction point, which is the basis of measurement of the land. It is his own evidence. In spite of objection raised by both the parties, the commissioner report has been accepted. This is the
order 26 commission.
Order 26.
Small issue, we can decide it.
Just I will show the evidence of the commissioner. He himself
after launch, ma'am.
3 junction.
Let after launch.
Anytime, not today, because a few other matters are there.
Okay, let it be on 21st for we can.
Interim order to continue.
Interim order to continue. Okay.
The 7th.
My lord. I please your lord. And item 57, I am for the OP2. The record of the record filed by the OP2 in the court of the Law and Civil Justice Senior Division Bhubaneswar and not collected, my lord.
What do you want?
My lord, a short adjournment after 1 week.
The last occasion, also we remember that civil dispute. The suit was compromised. It has already been acted upon. All the land they got in the compromise, they have sold out the sale. Thereafter, they filed the CMA, saying that there is fraud in it after selling all the land. Thereafter, two cases. This is time.
No, because there is yesterday there is a Supreme Court judgment on this aspect. Let's check it up. Next time I'll yesterday. Well, on the request of Court Counsel for the opposite party, leaves the matter on so and so interim order to continue.
On
interim order to continue, he will give a date. 1 week after.
interim order to continue.
Interim order to continue.
58, my lord, I pray for any other. Hon'Ble argue this matter, my lord. He is ill today, my lord.
My lord, I am appearing through VC, my lord.
Yes.
This is a case of 2019, my lord.
Yes.
My lord, there is a stay which is continuing since then, my lord. Though the learned court below has taken cognizance of the matter.
This is, my lord, civil dispute between the parties, both are the family members. And the petitioner is a lawyer, my lord.
But he is opposing your prayer for bail.
My lord,
2019,
time, my lord, he may be vacated, my lord.
See, 2019, stay order is passed.
Lordship, any Mr. Sarangi is ill, my lord, and he has to argue this case, my lord. That is my product meeting, nothing else.
See, 2019, 11th November 2019, the stay order was passed.
Next week, any day, my lord, we take it up.
What are the offenses?
Offenses that I.
420, 467, 468, and 471, my lord.
Is there any chance of settlement?
No, my lord, there are no chances of settlement.
Why?
My lord, here there are antecedents. The conduct of the accused persons in this case is very important, my lord. What he has done is property of grandfather. He has sold it to her name by representing his father as the grandfather.
Impersonation.
Yes.
Impersonation.
Yes, sir.
Would you on behalf of Mr. In fact, on the ground of senior counsel, no adjournment should be given.
No, my lord, only illness, because
maybe senior counsels are engaged date wise. If he any inconvenience, engage another senior counsel. What is the purpose of senior counsel then? Senior counsels don't hold a brief.
No, my lord.
They don't hold a brief.
And that when the metro
One
was
senior counsel is not available, you engage another senior counsel. That is the purpose of having senior.
In 19, Mr. Sarangi was not elevated as a senior counsel.
19, Mr. Sarangi was not a senior counsel.
Yes.
Therefore, he was holding. Say he got designation, then the brief goes.
And client's interest is, my lord. She is the lawyer. She wanted to.
Vakalatnama has been changed or not? Let us see first of all. You will change the Vakalatnama first of all.
Then, my lord, I will file. My name is also there, perhaps. And Mr.
Your name is there.
Yes, my lord.
So you are holding the Vakalatnama, then you should argue.
She has instructed. But
okay. He is not well. Mr. Sarangi is not well. I'll just after a week. So. But next time you have to argue. That's not a ground, huh?
Yes, ma'am.
Yes.
59.
Entry words to continue, my lord. Obliged.
Item 59, my lords.
Yes.
This is a case of two FIRs on the self-same cause of action. My lords, the first FIR was initiated by FIR number 79 of 2016 in Kalinganagar PS, my lord.
Yes.
That ended up with the present accused person not being charge sheeted in that FIR, my lords. So that FIR was instituted by a host of complainants, my lords. 40 complainants instituted that FIR. Allegation of 420. So when the charge sheet ended in one person being made the accused and we being exonerated in that charge sheet, the complainant, the present complainant, which I have challenged why this criminal Miss case, my lords, instituted another complaint case on the self-same cause of action, stating that so and so incident has occurred, and I am filing this instant complaint, which is wholly not maintainable, my lords. My lords, I will demonstrate to your lordship. My lords, may kindly see for a moment Annexure 4
You are appearing for the opposite side?
in the same case, my lords.
Who is appearing
Here
for
is
the
the case, your
complainant?
lordship.
Who is appearing for the complainant, first of all, let us?
Complaint by notice.
Yes, arising out of a complaint case.
Yes, yes, lordship.
Who is appearing? Notice has been issued? Just notice, sir.
Nobody has entered.
No one's
There is no
appearing for
noting,
the
your lordship.
complainant. Notice
Let us
issued.
see. Notice is over. This is pending since
2022.
2013. 1, 2, 3, 4, 5, 6, 7, 8, 9 hearings.
In fact, initially they have not informed the complaint as in opposite party number 2, your lordship. By the honorable court's direction, coordinate bench directed to impede the complainant as the opposite party number 2. Thereafter, might have my learned friend is incorporate the complaint as opposite party number 2. That part I have no instruction because I have no copy of the constituted court title of this petition lordship. And since 2022, nobody has entered appearance for the OP2 complainant, your lordship. There is a judicial order, lordship, to make incorporate the complaint as opposite party 2, your lordship. So for
That's right, but now the opposite party who is there.
My lords.
Why service is not complete? What is the reason? Let's check it up.
And here is a case, initially first FIR, by lodging on FIR, this case was initiated. Therefore, another person has lodged in complaint case and by the order of JMFC Chandigarh, that case is initiated, your lordship.
Not another, my lords.
Yes.
Same complainant.
Let
us see why the opposite party is not entering into it.
Yes, your lordship.
Service is complete or not? Pick it up. Thereafter, service. When the notice was issued to the complainant, it's going on and on. When was the notice issued? Huh?
159.
Yes.
My lords.
When the notice was issued?
My lords.
See, 8/3/2022.
My lords.
Opposite party number 2 is added.
My lords.
Okay. Thereafter, tell me when the notice was issued.
My lords, the case has been pending by the state, my lords.
But notice has to go to the opposite party. You have not taken any step towards that. And interim order is passed and going on and on.
My lords.
Although by the order dated 8/3/2022, or the informant has been added as opposite party number 2. However, the notice has on opposite party number 2 has been sure. The petitioner is directed to take necessary step to serve opposite party number 2 on opposite party number 2 positively by next date of hearing. Release the matter on keep it on 25th of April. Necessary steps for requisites to be filed by tomorrow. By tomorrow, release the matter on 25th and the interim order to continue. Yes. Take by tomorrow, requisites.
60, my lords.
60
But
lordship.
interim order is.
These are viceroy external.
Yes.
Item 60, my lord. I'm appearing on behalf for the OP2, my lord. Bring for.
Yes.
Maybe taken up after 1 week. We will file the counter.
Mediation failed.
Mediation failed.
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 The matter was referred to
Arbitration is continuing.
and our mediation has been unsuccessful. Release the matter for final court. Yes.
Interim order to
Interim order to continue. Yes.
Publish.
deep.
61.
Yes.
Fifth month running, since your lordship heard the matter and formulated the question, has suffered 4 adjournments. My 11th of
By way of
December.
last opportunity, 1 week time is granted to the land counsel for the state to obtain instruction in the present case.
My learned friend Mr. Biswal was there on the last occasion.
The same story is being repeated. I don't know why.
Extremely sorry, Your Lordship, that.
I'll just read the orders.
11th of
Let us read
December.
the order. See, I will not go far, but here, 11th on 24, Mr. Janna. Thereafter, 15/1/2025, M.K. Mahanti. Thereafter, on 5/2/2025, B. Naik. Thereafter, on 11/3/2025, S.N. Vishwal. What is happening? How many times I'll write this kind of orders? In 3 matters, I have referred it to the Advocate General. Every date of hearing, one lawyer comes and says that what is going on? Interim orders are continuing. What I'll do is I'll record everything. I'll allow it. I'll set aside. I'll allow in his favor. Let the message go very clear.
What do you? Your Lordship, it could be prejudiced to us, Your Lordship. But in fact, what happened, my learned senior is challenging whether.
Friday, I passed 2 orders.
Your Lordship.
2 orders. It's same kind of. Why are you doing all this thing? Why can't you set your house in order?
Is it pure question of law?
Every day of hearing one lawyer. And you must not be having the file now.
I have gone through the file, but in order to satisfy the better, Lordship, 2-3 judgments are required, Lordship. If in case in technically the in-house committee, the petitioner exonerated, that doesn't mean exonerated in the criminal proceeding. In that exonerated committee has technically have exonerated the accused petitioner, Lordship, in this case over my.
You first of all tell me, are you sure that you are a petitioner?
Yes, Your Lordship.
Sure.
Yes, Your Lordship.
Next time somebody else will come.
No, Your Lordship, I am undertaken to argue this matter in next date of hearing.
17th, 3 o'clock. You argue.
Yes, Your Lordship.
17th, 3 o'clock, no urgent.
Yes, yes.
Mr. Mahanti, in the present matter, I'll record that right on. This matter was reached on 5/11/2024 when Mr. S.N. Vishwal had appeared for the state. Subsequently, on 11/12/2024, Mr. U.R. Jain appeared. Then on 15/1/2025, Mr. M.K. Mahanti, AAC, appeared. On 5/2/2025, Mr. B. Naik, AGA, appeared. On 11/3/2025, again Mr. AAC appeared for the state and sought time for getting instruction. Today, Mr. Mahanti appears for the state and seeks an adjournment to prepare the matter. Earlier, this court has expressed displeasure about the manner in which the state councils are being changed frequently on every date of hearing, and the order has been already communicated to learned Advocate General. Despite that, it is found that invariably in all the matters, the state councils are being changed on every date of hearing. This is creating enormous trouble for the court as well as the parties concerned. It is made clear that this pattern of changing the lawyer on every date of hearing by the state council will not be tolerated, and henceforth, by way of last opportunity, Mr. Mahanti is accommodated, release the matter on 20th at 3 o'clock for final disposal. copy of this order be communicated to the office of learned advocate. Friday also I did the same thing. Before that, 3 matters, 4 matters I have
The
done.
Lordship may also record a strong opposition to this prayer for adjournment time and again.
Yes.
Your Lordship may
See,
record
the
that.
interim order is operating from
Interim order.
I tell you, interim order in the present case is operating from 9/11/2022. Since the state has been taking time, 1, 2, 3, 4, 5 ordinance. State has taken 5 ordinance. Mr. Mukherjee is strongly opposing the adjournment. Please don't do it. Why don't you have a weekend meeting? And I told you the other day, 10 o'clock, you people come here and just see who is handling which case. And distribute yourself.
The interim order.
Interim order, yes.
Item 62 may pay after launch.
Pass. Pass over.
Sixty-three that. ठीक है, तो लाइब्रेरी से डिसाइड किया है. No. Criminal discuss is 2306. आवश्यक है वो किसी अलग नहीं. गुड की होता है. इधर डिफी केस में पहले इतना की पक्का ना है.
What to do? In the morning, somebody mentions and says that connected matters. Yeah, okay, it's all right. If let us see what is this matter. Key mention was ended. Check it up and tell you. You can't mislead like this. Check it up and it launch time to phone call. Yes. What is this matter? Yes.
The petitioner challenges the order of cognizance dated 28/10/2022 under cognizance of 31 of domestic violence act on 2 grounds. One, first, this petitioner is now responding in leaving this case.
You are appearing for whom?
I am appearing for the person aggrieved, the wife. On the 2 grounds. One, this petitioner is not respondent in the 12DB miscase. Second, this is not related to, this is related to section order. So section 31 is not attached. Section 31 says, let's see, we permanent place.
Deviate.
Yes.
Yes.
Penalty for breach of protection order by the respondent. If breach of protection order or of an interim protection order by the respondent shall be under this act and shall be punished with imprisonment either discretion for term which may be extended to 1 year with fine which may be extended to 20,000 rupees or both. Here this petition or respondent in 12DB case, I have already annexed the 12DB case, which is annexure number 1,
He should be a respondent. He should be a respondent. Okay. Yes. Annexure?
1,
1. What is your name?
Running page 7.
1 minute. You are Suresh Kumar.
Yes, ma'am.
Yes. You are not respondent. Yes.
And order is related to your resident order, not protection order. Let's secondly see the complaint petition running page. Annexure 3, running page. Running page 15,
Yes. Yes.
During the course of staying, as the created a.
This is the complaint.
Yes, madam.
Yes.
Page 15, running page.
Yes.
File in CMC on DB Act for maintenance of resident orders.
Maintenance and
resident order. This is a breach of resident order.
Where is the order? Where is the order? Which is sought to be executed now?
As you kindly see, the order is, order is annexure 3, The order dated 28/10/2022, madam.
Where is that order? 20.
On page 19, my lord.
Yes, let us read again.
I think the order of convenience.
Order is in my record. Let's kindly list the order 18. 18, page 18, my lord. Their evidence, initial statement. In
See,
complaint.
cognizance is taken against see, prima facie under section 31 deviated made out against the accused persons named in the complaint petition.
Yes, my lord.
Your name.
Yes, I'm not responding well,
Then summon is issued to you.
Yes, madam.
Where is that summon?
Let's kindly list the cost title, page 19, my lord.
Where is the summon? Pursuant to this order,
Yes, madam.
the summon is issued to you. Why have you come? Cognizance is not
Someone
taken.
issue, my lord.
Show me where have you said that summon is issued?
Let's see, kindly see the cost title, my lord. Let's see page 19.
19?
Not on page 19, my lord.
Yes.
On page
19,
19. I am the accused in part 4, my lord. Accused number 4. Suresh Kumar Gantia. Cost title, my lord.
Yes, Suresh Gupta. Yes. 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 In section 12, he was not a party.
Yes.
Can you
Yes, sir.
proceed?
Madam. That was the question which was raised and I have taken time for the same. That's
Because the expression used in 31 is respondent.
2Q. 2Q is the definition of respondent.
Yes. 2Q.
Which has been stated to be by the apex court and other courts has not been happily worded.
Yes. 2Q.
2Q.
Yes. Respondent means
It's any other male member who is or has been in a domestic relationship with the agreed person and against whom the agreed person has sought any relief.
Against whom the agreed person sought any relief.
That was by submission, and my another friend submission is also the same. Today. Yes, sir. But that order was passed under section, after this petition was filed under section 12 of the Act. Order was passed under section 19. Order can be passed under 18 and 19. 19 deals with right to residence. Accordingly, the order was passed. So, initially, my learned friend is quite correct in his submission. The effect that application under section 12 was filed against husband and parents-in-law. Present petitioner before my lord is the brother-in-law, the owner. The question comes up whether he can be taken as an accused
in 31.
If any complaint has been filed as per this section.
And 31 also says that against.
My lord, at this juncture, I want to draw my lord's kind attention to Rule 15 of Domestic Protection of Women from Domestic Violence Rules 2006. Rule 15.
Rule 15.
My lord.
Yes. Yes.
Rule 15 deals with breach of protection orders.
Yes.
While let me kindly see. Seven.
Yes, 7.
Subrule 7.
Any residence.
Any resistance to the enforcement of the orders, the code under the Act by the respondent or any other person purportedly acting on his behalf shall be deemed to be a breach of protection order or an interim protection order covered under the Act.
But this is a rule.
Valid rule. I am coming to that.
The statute bars.
Valid.
Then?
No, valid. Rule 4 beforehand, valid. The aggrieved person may, if so desires, makes a complaint of breach of protection order or interim protection order directly to the magistrate or the police.
That's right, no problem.
Here, my lord, there is
against whom? That's the question. Is
against whom, my lord, the person, any person purportedly acting on his behalf. Because initially the protection order was passed against husband and in-laws, parents-in-laws.
There's no res judicata. You file a fresh 12 if you want.
No. That's true.
Press 12 against him.
My lord,
How can you,
My lord, at this juncture, my lord, I want to say what was the intention of the
Oh,
legislature.
no.
No,
The
my-
statute is very clear.
If the judgment is not there in this line by this court, my lord can pass an order accepting my submission.
I can't realize the scope of the act with the statute bars.
My lord can reject my submission, accept my submission, but relying upon the.
Why to travel writing a big judgment on this? Because the statute is very clear.
I am trying to draw.
And see, the definition itself is hurting you
I
now.
am trying to draw my lord's attention to Hill's rule of interpretation of statute. What was the intention of legislature?
Can I ignore 2Q and 31? Reading.
My lord, on the reading of section.
Rule.
On the reading of section 12, 19, 31 rules, 2006 rules, rule 15, I think my lord, the proper construction would be if person is not there as responded in section 12 application, he or she can also be taken as a.
But see, rightly you have taken me to 31 where the expression used is respondent.
Respondent.
Now go to the respondent definition. Definition also says that.
My lord,
Do you have any judgment to support?
my lord,
Do you have any judgment to?
yes, respondent can be respondents. My lord, this that has been decided to some extent in my lord. In the case, in this slide, not in the case of Review Act.
Yes.
Before going to that decision, my lord, I want to say it's a beneficial statute. As because the family put law, my lord, that was not sufficient to balance this protection of women from domestic violence act was drafted in the year 2000.
Beneficial statute not at cost of someone else who was not even a party.
Beneficial statute, my lord, the intention, if my lord must have seen that off-quoted judgment of Lord Denning to the effect, if a particular defect appears in a particular statute, a judge will not see to folded hands and will blame the draftsman. They should do what they should have done, and in the process, they would like.
You may be correct, but the construction of a provision has to be made in accordance with.
Yes,
if the language is very clear, why should it be?
Yes, last occasion I was drawing my lord's attention to the judgment of Honorable Justice Sikri.
Yes.
My lord, where that is 2010, volume 118 DRJ.
Can I get it?
I had given on the last occasion. Okay.
2010, huh?
I had given, perhaps possibly in the file.
Copy achieve. And it's not scanned.
That language is this valid. I'm just replying. When we interpret the provisions of section 2Q in the context of the aforesaid scheme, our question would be that the petition is maintainable, being against woman in the situation and so on. So, no doubt the provision is not very satisfactorily worded, and there appears to be some ambiguity in the definition of respondent as contained in section 2Q. The director of Southern Institute of Social Sciences Research, so and so, has described the ambiguity of section 2Q as loopholes to escape the respondents from the court of this law and opined in the following words. As per section 2, clause Q, the respondent means any adult male person who is or has been in a domestic relationship. Hence, a plain reading of the act would show that an application will not lie under the provisions of this act against a female. That has been included later. But when section 19(1) proviso is perused, it can be seen that the petition is maintainable. But this loophole has been blocked. It has been answered. But then the courts are not supposed to throw their hands up to the expressing their helplessness. It becomes the duty of the court to give a correct interpretation to such a provision having regard to the purpose ought to be achieved by enacting a particular legislation. My Lord, Honorable Court was pleased to refer decision of the Apex Court 1999, volume 8, SCC, page 139. Proceeding to interpret, my Lord, they have interpreted my Lord, his role. Very well.
By the way, who is the petitioner?
His
brother-in-law.
Brother-in-law, own brother-in-law. He was not creating disturbance, so I have not made him a party. Now he is, well, this parents-in-law and brother-in-law, four of them have been taken as an accused in the complaint itself. On perusal of the complaint, magistrate has taken cognizance. One mistake magistrate has come, whether he has living 31 or he can come to a member as a member of the family, and as per Rule 7, any resistance to the enforcement of the orders of the court under the act by the respondent, I'll have to see again.
Again, that rule, huh?
Rule 7.
Yes. Yes. Yes.
But again, I'm reading. Any resistance to the enforcement of the order put under the act by the respondent
or any other person.
The respondent means the respondent, those who were taken as respondent in section 12.
Or any other person.
Yes. Or any
purportedly acting on behalf of.
Acting on his behalf.
But unless you make out a point.
I have made out a point by.
Where is your complaint? Where have you said
yes,
that the 12 is taken against X and Y? But Z is creating problem for implementation of the order. Where is that?
Page 13.
13. 1-3. Yes. Yes.
And this Suresh Kumar Kanthia.
So you have made him. Yes. Where is the amendment?
My amendment is column 8.
Yes. Read it. For him, what are you seeing?
Madam.
Last paragraph. After obtaining the order.
The court's
Courts. Complainant and her son.
Complainant and her son.
Went to the state house.
Stayed there on 20th July 2020.
Found
the house was locked. Returned back and handed over a copy of the court's order to IIC Gania PS. Again on 21/7/2022 at about 10 a.m. The complainant, the person's son and his father appeared in the house of the in-laws situated in Suvarnapur, and entered to the house, stay as per the order of the court, and shown the order to them. By time of entering into the house, all the accused persons obstructed the aggrieved person, possibly prohibited to enter into the house, not abused and not permitted, and threatened or
you have not make a specific allegation against this petitioner at all. I read it full.
Towards the last, but
only you say that.
But when we entered the accused number 4, Suresh Kumar Kanthia, with a threat, chased to assault and did not permit to enter another accused.
Where you are in that part?
That part is different lines.
That I didn't get anywhere.
Page 16.
16, huh? Yes, you crossed 15. Okay.
When we entered it.
Then in page 15 there is nothing. 16 where you see it? On 9/12/2022 at 9 p.m. the complainant along with the
4 lines there. When we entered accused number 4, Suresh number.
Yes, accused number 4, Suresh Kanthia with a threat says to assert Did not permit to, yes.
Let's see, times page 18, madam. Page 18, the initial statement, madam, for complement.
No. What it says, let's see, come to the rule.
Yes, madam.
Rule 15.
Rule 7, my lord.
Rule 15(7).
my lord. Any
15th of
resistance
Rule
to
10. It's any resistance
enforcement of order.
to the enforcement of the order.
My lord, execution of order, my lord. Execution, enforcement means my execution of order.
Yes.
Yes, my lord.
31 is in the form of execution.
They have
31 is in the form of
my lord.
execution.
But here, my lord, any resistance to enforcement order.
What he says is, you have created resistance for compliance of 12 order, therefore 31.
No, my lord. What is, my lord? Resistance to enforcement order. No, enforcement execution. No execution file to the order of
What
this
is
order of the
30?
12 DBI, my lord.
What is 31? Just see this
Yes, my lord.
31. It is the form of execution only.
Yes, my lord.
31.
31 is a form of execution, my lord.
Yes.
But here, my lord,
No,
in instance.
See, he has 2 points.
Yes, ma'am.
One point is Justice Sikri's judgment. We says that 2Q,
Yes, ma'am.
the definition of respondent,
Yes.
should be wide enough
Yes.
to give the purpose of the act to the effect.
They not made me party as one respond in the.
That everybody knows.
Yes.
12 we were not made the
Ma'am.
party. There was a not put to execution through 31.
Yes.
In 31 you were made
31 therefore,
one,
madam.
31 you were made an accused. Number 4.
Oh, yeah.
And there is a specific allegation against you that you prevented.
Yes, ma'am.
And now read 15(7).
Yes, madam.
15(7) uses the expression any person who is purported to be acting on behalf
Yes,
of
madam. First, my lord, any
respondent
resistance of
and create resistance.
that's it, any resistance enforcement order of the court, my lord. Means, my lord, when order will pass for resistance order, my lord, if there is any execution order, then my lord, it will apply, my lord. Order 31 is there from my lord. 31 is there from my lord. That's the analysis to what, my lord.
Petition was filed on the second
7, my lord. That's the analysis.
Read the top.
Yes, my lord.
15.
Yes, my lord.
Any agreed person
may report
may
a breach of protection.
a breach of protection order
my lord. That's it.
or an interim protection order
Yes, my lord.
to the protection officer.
This is
And
my lord, not a protection order. This is a receiving order, my lord.
No.
Page 18, my lord. That's you can see.
8, yeah?
Page 18, my lord.
18, okay.
That's you can see.
Hmm.
Record English statement. I had filed a DBM's case in which this court directed the accused person to allow me reside in the Marital house. But in spite of receiving order, 15/7/2000, above accused person not allow me enter into the residence, for which I filed answer. This is breach of residence order, my lord. Residence order not comes under my lord.
My lord,
Protection order.
take
1 minute. Residence order.
basic,
Yes, my lord.
petition was filed.
Residence order is section 19.
Eight minute residence order.
Never seen.
Definition of residence order.
Yes, ma'am. Residence, my section 19 is residence order, my lord.
19?
18 is protection.
19?
Is residence order 19.
15. See, madam, restraining the respondent or any of his relatives from entering any person in which they resides.
The resident order, clear resident order.
It needs,
Breach of protection order.
little hearing. Needs little.
That's a breach of-
Interpretation.
Breach of protection order, my lord. But it is breach of resident order. Resident not comes under 31, my lord.
Part heard, partly heard. Please the matter on to Interim to continue.
Interim order.
It is little heavy. Because the rule, if you read the rule with the definition clause and 31, there is a point. And
This is protection, violation, my lord, violation, breach of protection order, attack section 31, my lord. They breach the resident order.
you want to get out of 15(7) saying that it is a residence order.
Yes, my lord.
I will satisfy.
What he says is, this being a residence order, 15 will not come to your
Well,
act.
I will satisfy.
Had it been a protection order, because this is 15 is only for protection order.
Yes.
He says that it's completely distinguished.
No, my lord. Language is
Let us delve upon it further. Interesting thing. Yes.
my lord.
I'll put it on 23rd, 24th.
21st.
23rd, 24th. 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 Yes.
Interim order.
Interim order. Yes. Thank you.
occasion, your lordship, the UD case record was called for. And because there was initially one FIR was lost, and subsequently at a different place, the deceased committed suicide, and there an UD case was registered. Subsequently, both the cases were tagged and investigation was done. And I challenged the initially order of cognizance at the stage of cognizance, and I was given liberty to raise at the time of the framing of charge by filing application 227, and accordingly I filed the application, and that has been rejected by the impugned order under Annex 1. That is under challenge with the lordship.
Sufficient evidence we have received the copy of charge sheet and all documents also. The UD case record is not necessary in this case. Because there are sufficient evidence, all evidence are existing.
What are you are seeking quashing of the ST case?
Yes, your lordship. The discharge petition has been rejected. Against that, I have come.
Yes.
This
But there is no order. There is no order calling for any record. There is no order.
I think Justice Sankar Mishra.
Which order? You tell me. Which order?
Order number 4 dated 1/9/2023.
Up-to-date case diary we produce for the perusal of this court. Further, UD case record in connection with death of the deceased shall be produced. Where is that?
Documents I have already received. When I placed the whole lands from the charge sheet.
Yes.
During investigation, it came to light that the
Where are you reading? Charge sheet. Okay. Yes. Yes. Yes.
Makes sense.
Yes.
During investigation, it came to light that the had in law books series. Victim. This is victim. When Sibo was tortured by her husband of her relation with Gandhi is the present person. She informed the fact to Gandhi and put pressure upon him to marry her. Getting assurance, Sibo remained silent. Taking opportunity to Gandhi put away Sibo on highway 22. Moreover, with a request to marry her. On highway 22, they both remained in hotel Dinar. In the said hotel, they both picked up quarrel on the issue of marriage. When Gandhi elected from me and suggested to take Sibo to Bhavanpatna, which Sibo did not agree. When Sibo thought that Gandhi will cheat her, and there was no way to back to her in-laws house. Agency remained in stress condition committed suicide and handled inside the hotel. This is not supported.
Direct delegation.
My lord, your lordship can have a glance in that person which my lord senior is placing. As per requisition of the PS UD case number, Nayagarh Town PS UD case number 15 dated 7/8/2022 was initiated. In that case, certain statements were recorded to show that at the time there was no quarrel, and also at the time when she committed suicide, the petitioner was not there inside the hotel. He had been to outside.
All these things are probable defense. What can I do?
So, but I'll
read the
prima facie
record
case.
some other case and
No,
look at the case and we
No, not some other case. This is this case. Because that case is tagged with this. After that, only charge sheet has been filed.
Oh, when the trial everything will be.
Well, here I am coming. I have come, but that there is no prima facie case of 307. Minimum ingredient of 306 is not made out. That is my challenge.
Yes, just see further. Read further. Read further. Read further.
Agency remained in stress condition and committed suicide by hanging inside the hotel room 105 of the Dinar Hotel. Marital, lacking door hooked inside by Gandhi had the reception counter for final payment and checkout. After final payment, Gandhi proceeded to room number 105 to bring the belongings. Found the room was closed inside. On repeated calls, as the room was not opened, Gandhi approached the hotel manager at the reception counter for help. So Gandhi himself, as well as the hotel manager, along with her other staff, opened the door
of the room by pushing and pulling and found that dead body of the Cindy was hanging by a sari in the ceiling of the room.
Yes.
And all the staffs also said there was a quarrel between them.
All 161 statement, everything is there.
No, no, my lord, 161 statement
I don't think
recorded
this is the
UD
case.
case. My lord, I am not going anywhere. I'm saying that UD case record may be called for your lordship may pass any order. I am not going away or I am not praying for a long adjournment, even 2 to 3 days adjournment.
This is pending since 2023.
My
for
lord,
no
since
reason.
2023 order has been passed.
What is the stage now? Trial stage.
No, charge has not been framed.
There is no stay also.
Yes, on 1/9/2023.
What is the problem? Is the stay is there and unnecessary?
My lord, it is their duty to produce the
Case is
UD
made out against.
My lord, 1/9/2023, there was a judicial order to produce the UD case record. With due respect, I submit that is it not my responsibility to apply with the order?
See, thereafter see the orders. There is a judicial order, but it's not thereafter. See how many hearings has taken place. 1/9/2023, 1/9/2023. There are 1, 2, 3, 4, 5, 7, 8 hearings.
Yes.
7 hearings.
Because of that, non-ability of that, the case was urgent. I could not address the case. Because
Yes, Mr. Naik, what do you say? See, there is an order. Just check it up. That is 1/9/2023. Do you have that with you?
I'm handing over the order passed by this court.
But see, not necessary, but there is an order. Thereafter, Mr. Rogada had short time. Thereafter, all the state council kept on asking for time. It was not necessary. I also have the same view. It's not necessary. But there is an order. See, the persons to the order dated 1/9/2023, the state council has not obtained the record of UD case. Hence, he seeks one last opportunity to obtain the record. Leaves the matter after 1 week. After 1 week. Interim order. Interim order. There is no interim order.
On 1/9/2023.
1/9/2023.
Order number 4, yours.
Adjournment application.
Yes, yes.
It may clear that no further. Yes. 7.
Thank you, Your Lordship. I appear on behalf of P number 2 and for which time for
opposite party. So entered appearance for the opposite party to file vote of no and 6 times for following response to the petition. Leaves the matter after 4 weeks. Yes. Well,
matter of compromise, Your Lordship.
May I please, Your Lordship? I am appearing for the informant, Your Lordship. I mean, VC, Your Lordship.
Is 34 is there, Your Lordship. There is more than one accused, Your Lordship. Here is the presence of one accused. But my responsibility, Lord, say.
What let you bring information if any other accused is there, then I have no.
Yes, yes, I have a copy of
show me the what is the stage now?
The stage only charge sheet has been filed.
Show me the charge sheet. Why to
apply the certified copy, Your Lordship.
Certificate copy is not necessary. You give me why to debate whether any other accused are there.
Another is there. People don't trial court, Your Lordship.
Where is the charge sheet? Show me.
That is not filed, Your Lordship. That my senior
Charge sheet filed, Your Lordship.
There is no record.
Not filed here.
Sorry, that is not filed here. I will obtain and file it, Your Lordship.
File.
Why are you laughing?
Why
are you laughing? Am I so wrong? Wrong.
I am not here.
Release the matter. After within a week, you please file.
Yes, yes, I will bring it up.
Yes.
Item 14, obligations.
And if other accused persons are there, make them a party.
There will be a party to the proceeding.
So that all the things.
Yes.
Obliged to Lordship.
Yes.
Supreme Lordship directed to verify the order.
Yes.
At the state.
Sangram Chitrapur. No. Whatever the order in your case, Sangram Kumar Panda.
Last time I'm giving your lordship.
What should I have provided? Lordship? That is ABL page number 1511 of 114 of 2020.
You are,
And in another, there is the name of the present petitioner lordship.
what is the order here? Where's the order?
Yes, sir.
This is the order.
Yes, sir.
Why have you not complied with the order?
Okay. That instruction I don't have.
Now, see, the problem is today you are saying that you will surrender and within in the same day your bail application should be considered. But the problem is in the earlier you had approached this court on 20th of December 2021. You have been directed to surrender. 10 days notice will be given. How can I dilute that order now? I can't dilute that order.
Also, my direct to surrender.
Right. Petitioner is although petitioner is seeking passing of the order dated 2/2022 passed by ADG Special Court POCSO, whereby cognizance of offences where is the order of cognizance of offences punishable under section section 341, 323, 506, 354B, 34 IPC, reading section 8 of POCSO, and section 3(1) RSW 3 Roman 2 VA of HCHA. It has page 16. 16 has been taken. Earlier, the petitioner and the other co-accused persons have approached this court by filing ABAPL number 15114 of 2021. The coordinator court directed the petitioner to rejected the application for grant of additional bail. However, granted liberty to surrender and move bail application. If surrender, move bail application. If the bail application is moved, 10 days notice were directed to be 10 days prior notice were directed to be given to the victim and IO of the case, and the hearing of application, regular bail application was directed. Subsequent thereto, one more co-accused person, namely Arpit Chauhan, moved separate anticipatory bail application being ABPL number 13647 of 2022. The said bail application was disposed of by order dated 21/10/2022 with the direction that the said petitioner shall appear before the court court, and the regular bail application shall be disposed of on the same day. Same day. We have been confident for the initial Marital and confident with the petitioner at the outset submits that he is not pursuing this application seeking question of the rather reserve the rights to agitate the issue before the trial court. However, he submits that the benefit of the order dated 20 bar of the other equity and equity loss of the other wife is passed by subordinate bench of this court in ABPL number 154 of 2021 and 13647 of 2022 shall be regarding that the submission made by Mr. Mahapatra, liberty granted to the petitioner to surrender before the court, surrender appeal before the court within a period of honor report 30th of April and brings up to the revenue available under law. So, on surrendering, we may move an application for grant of bail on all the grounds, including the ground of pilot. This is you can come with the same day. I've done it, yes.
Item 22.
22, your lordship. And the request of the for the petitioner adjourned to 4 weeks.
29.
Senior stats. Annexer 1 copy of FR and the annexer 2 copy of charge sheet. They're not legible.
All right, I'll
Not
give you a type
legible.
copy. I have the same copy. I'll give him type copy.
Okay. The annexer 1 and 2 to the petition is not legible. There is
Legible copy by next week.
Seeks 1 week accommodation to place on record type copy of the same. This matter after 1 week.
31.
Sorry?
3 times the petitioner filed anticipatory bail, which were rejected in this application of simply praying first
Anticipatory bail rejected twice.
price.
Thrice. So what do you want now?
First or second.
Huh?
First or second.
It's already rejected, what to do? Thrice. Not once also.
Simply praying for first or second.
Madam, what are you seeking here? Quashing. Or petitioner is seeking quashing of the PS case. Kakriguma PS case number 4 of 2024. Registered as for him for a late commission of offense under section so. The petitioner they approached 3 times this court seeking anticipatory bail. Petitioner approached unsuccessfully approached 3 times. Unsuccessfully approached 3 times to this court. Grant of continuity bail which has been rejected. Firstly, petitioner moved application on application ABPL number 1519 of 2024, which came to be dismissed by the President Bench of this court on 26/2/2024. Subsequent thereto again, he moved an application ABPL number 6897 of 2024, which was turned down by this court on 19/7/2024. The last application of the petitioner being ABPL number 2965 of 2025 also came to be dismissed by the court on 21/3/2025. The petitioner in this present proceeding, although it can be seeking scrapping of the entire criminal proceeding, however, submits that he will not press his petition, rather prefer to appear surrender before the court and refer to the remedy available in law. On instruction, the learned counsel of the petition submits before the court on or before 30th of April 2025, resort to the remedy available under law. We is open for the petitioner to move to regular bill application before the court below on all the grounds as have been urged in this petition. And if that application is moved, then it can be considered on the same day. Yes, sir.
44.
Please move.
Yes. Huh?
Democration party questions are available.
What is he seeking here?
Yes, ma'am. The allegation of the wife against the husband and another person also. Both are pursued with their relation with the wife. And they have also killed that.
Non-appeals for the parties, even in the second call, in the interest of justice, that then after 4 weeks. Yes.
55. $62.
55 it will come. Yes. Yes. 55. Yes, who is appearing? Notice issue. Appear. The present matter is pending since 3/3/2020. On 1/7/2020, the court has passed an interim direction saying the execution proceeding in execution case number 1 of 2012, pending in the court of civil junior division, Pipili. None appears for the parties even in the second call. Even in the second call. In the interest of justice, last opportunity is granted to the last opportunity is granted. These counsel made clear that if the parties goes unrepresented and make it appearing, the interim order passed on 1/7/2020 shall be automatically repeated. Yes.
62. Matter will be settled and a petition and the complainant present before this and report by the CORAM because of some civil issue, FIR was lost by the complainant and actually the proceeding. No charge sheet has not been submitted to the matter. Matter in the meantime and settled.
What are the allegations?
Sorry, madam?
What are the allegations?
Allegation is that by forging some impersonation of some documents, LBD has been executed in the name of others.
How many accused are there?
There are 5 persons, 5 number of accused.
State
Case are registered against 5 number of accused persons. In the meantime, charge sheet has not been done. That is still in.
But only one of them has come. We don't know what is the complexity. What is the stage?
I have no instruction for the time being. The Lordship, let from next week, Lordship obtain instruction on then whether statute is filed or not.
When what is the practice when you get advance copy? What?
But my record suggests that already earlier notice has been issued to the IIC concerned police station for call for the CD and to in order to
This
verify
matter is
after-
pending since 2022.
Yes, yes, Lordship.
What instruction you have done?
Allegation against the present petition is that the present petition was
The notice was issued on 8th 12 December 2022.
Yes, yes, Lordship. 18.
What instruction you have?
Lordship for 9, report 9.
It's not first time it is not
Yes, no,
coming.
you know,
See,
that's-
1, 2, 3, 4, 5, 6, 7 hearings.
Only 18, 12, and 24 lordship, this only court is directed to verify the affidavit from the concerned IO lordship. That effect, the letter has not been issued. That effect, I have no instruction whether that.
See, this
Yes,
is
yes.
not casual.
Yes, I am
See,
actually.
advance notice are given to you. Matters are pending. You without any instruction, if you are there, unnecessary matters are pending.
Let it come next week or in the meantime, convert whether that been filed or not. Procedural. Instruction.
In all the matters, you people are doing like that. Simply, there is no instruction. The state council seeks an adjournment because he doesn't have any instruction. Reach the matter. I am not sure whether they can get it the instruction or not. That's the problem. I'm not getting any effective assistance. I used to dispose of about 100 matters a day. 120 matters I used to take up. Now I reduced down to 70, less than 70. Even then, there is no cooperation from you. Matters are unnecessary pending. In 2008, stay from 2008-9, stay is operating. You people are not getting any instruction. Yes. Yes. 64. Four 20.
Complaint matter. Allegation matter. This very petitioner proved 3,01,400. 3,01,400 from the info to provide a land matter. Subsequently, did not return the money.
Are you a builder?
Yes, ma'am.
That's the problem.
Only amount is 3,01,000.
No, but here, but how many people you have cheated? That's the question.
Cash is submitted matter against one. That's it. Can
Yes, state, you are the opioid.
Cash is submitted.
Huh?
Section 6 opioid is there.
Then?
Cash is submitted matter against one person matter.
But the section 6 OPAD, how will I quash it? Show me any judgments. Can I quash it? Can I quash it? OPAD.
Amount is 3 lakhs and one person matter. Classically, I submit charge sheet.
Then how have they what is the amount? 3 lakhs.
3 lakhs.
Then how OPAD they will invoke? How? There must be something. Do you have any material against him?
I have no material in that. Cash is for one person.
Now how OPAD is made out? 3 lakh rupees, 1%, 420. How to invoke OPAD? That's what I'm asking.
Submitting me lot. Let him file the petition before the law and trial court. Let him take a decision.
OPAD and charge sheet is filed and OPAD and
420, 34 IPC and 6 OPAD.
6 OPAD is cannot be is not compatible.
No, not compatible.
So then why what he will file? I am just asking if it is 3 lakh rupees, it is only one complaint. There is no other material. How have you invoked 6 and 6?
Next week after.
Section 6 is not made out if the story is correct. Yes.
Informed present matter to them.
What to do? You should have challenged you are asking for quashing of section 6 also. Read the facts. What are the facts? Read the charge sheet.
Yes,
How have they made? Huh?
Turning page 15 matter.
Yes. Read it.
Read that matter. On 23/6/2015 at about 2:30 p.m. one Sanjukta Sethi, wife of Ambuja Vallabh Sethi of Station Bazar, Patan number so and so College Square, is Malgadam Patan, alleged in writing before the IIC to the effect that accused person Kishore Chandra and Damayanti Naik, proprietor Vasundhara Land and Development Private Limited, plot number so and so Mahanadibar Cutter, persuaded her in the year 2011 to purchase land from them by paying rupees 3,01,000 for a piece of land, measuring 1 gun, believing on their words. She entered into the agreement on 13/9/2011 and paid rupees 3,01,400. The accused person have also handed over the money received and EMI collection received in different dates. As per the agreement, they have not been registered in the land with the stipulated time. So she approached the accused
Yes,
person.
Mr. Justice. How you brought section 6?
There are getting one instruction, Miller. Further, apart from present petitioner, any other are there, Miller?
You take fact as it is.
Miller.
How will you make out section 6, you tell me? No section 6 is made out.
From next week after that.
Okay, next week.
I
Date would be out.
know. That no. Interim model is there.
Interim model. Content. It can be disposed of. What is this? They have settled the dispute because of section 6. Section 6 is not made out at all. I'll pass section 6 and allow them to go. Next week. You check section 6 is not made out. Because of section 6, settlement is not possible. Section 6 is not made out from the very.
Asmita case, Patra case is pending, that's why not happening.
65.
Answer one of taking cognizance against the brother-in-law and sister-in-law for all element regarding it Bangalore being implicated in the case and cognizance been taken, and she has already made allegation in general in nature against all the family members. And
Who is appearing for opposite party member? Who?
This was issued
Service difference?
to the informant. What you see have not.
and they divorce case against the husband. They are at the and
None appears. Yes. Notice sufficient.
Notice.
Yes, yes.
notice are already filed into that in the spirit of
Let notice through IA.
Notice all those assured of an opposite party member, but none has entered appear in the interest of justice. Notice on opposite party number 2 be served through IIC. No? IIC which police station? IIC police station. Narsingpur police station. Please see matter on and say interim order to continue. Baleshwar.
Yes.
Baleshwar. Baleshwar.
No, in the other time, my
Yes.
39.
ठीक है बालेश्वर
My eye is pending my long time.
stay for the ठीक
Take pleasure, Lordship. This is an application filed by the in-laws arising out of matrimonial dispute.
Yes.
The mediation, your Lordship, was sent to mediation.
Yes,
Last
okay.
occasion, yes,
Mediation
last
is
occasion, my lord was pleased to put a question. That is, there is because my lord, the reason that I offered certain amount, they didn't agree. That's why, Lordship, last occasion asked
how much you offered?
Yes, I offered initially 13, then went to 15 lakhs.
What is their demand?
It is wrong.
15 lakhs.
In fact, the father-in-law had agreed for 30 lakhs. His advisor not to accept it.
But your demand is 30.
That has been agreed.
He's coming up to 15.
My lord, Lordship, kindly consider the plight. The petitioner, the husband, is working as a junior librarian in Acharya.
You have offered 15.
Well, I have offered 15 lakhs. Also, I have taken instruction. Also, my client is here to go up to 17 lakhs. Today, my instruction beyond 17 lakhs because can you see? He is getting 23,000 is the basic and gross is 34,000. Initially, he was getting in the year 2020 about 9,000. Then he subsequently, when the services regularized, he got a salary of 34,000. And he's posted at Cancer Institute at Acharya Harihar. father is
How much
retired
he has,
teacher.
what is your instruction? How much?
My instruction 17 lakhs
No,
as a whole.
final instruction. He might have said that you start from
No, my lord.
to,
Blood,
you
I have
tell me the
also-
final amount.
I have also asked my
You tell me the final amount, why to waste time? What is your instruction? Forget
Sir,
about that.
17 lakhs.
17, he has said, asked you to start from 17. To how much you tell me? Then I'll decide. 20, he might have told you 20.
The father has suffered a massive heart attack, 5 lakhs. They have
Don't tell how the story. He might have told you 20. Start from 17, it will go up to 20. He might have told you like that. And he's offering 20. Take 20 and finish it up. Why?
I don't know. I have to take instruction, but she has
20.
But she has stated that let it go to 12.
See, ultimately, at the end of the day, after
understand-
2-3 years, you'll do
My
the
lord,
same thing.
My lord, I understand that, and I always advise that go for mediation and settle it.
And you know, after 2-3 years, you will again settle.
Always
Today, better 20. Take 20 and finish it up.
But what happens? The father is retired. Father has been able to support.
Let him and put it on Monday, 20.
Everything is being specified to touch your lordship's appropriate court. Nothing truth. Nothing is true.
I'm not getting influenced by that. See, I'm only looking at two things.
Yes.
You demanded 30, he's saying 15. In between something, I'll fix up and finish it up.
I don't know.
That's what I look
I have
at.
to take instruction, but there is absolutely no.
According to me, 20 is, right now we can give up to 20.
Can you see? The position is also not.
Again, I can say many things.
I don't want to hear. I don't want to hear.
Yes, that is what I'm submitting.
I don't want to.
That is what I'm
Come with the, are you agreeable to 20? You tell me.
No, I have to take it. I cannot decide anything.
That's what I'm saying. I'll put it on 15th. Friday. You come and tell me. Otherwise, we'll hear it on Monday. 20.
Yes.
Okay.
I will take instruction only.
You can't agree without 20. No, 11.
15?
No, 11.
11. Yes.
He'll come and tell whether agreeable 20, then it's all right. Otherwise,
It may not be possible. Next
Monday.
Friday. Next Friday.
15.
No, next Friday. Monday is a holiday.
So 17?
15.
15? 16? 16? I will also have to take instruction up to 20 because I will convince them.
Not 20. Beyond 20, you think of.
My lord, kindly see.
20 is seal.
My lord,
don't negotiate less than 20 and think of paying 1-2 more lakh rupees so that it will be that.
And your lordship know
it will be somewhere within 25 or so. And
your lordship will see the condition of the husband. Husband is getting only that much.
Don't make false attempt to reduce.
No, I am not.
Reduce less than 20.
I will
think of paying 1-2 more lakh.
Done. I will take all endeavor to at least whatever the father is staying at Jaipur.
He will end up
and father is not helping because the father
will end up spending more money in litigation. I tell you.
Yes, that is only 4-5 litigation there. But the husband only.
Everything.
I'll convince them. I'll try to take to up to that your lordships.
Right.
Okay. Interim order to continue.
Interim order. Yes.
I have challenged the order taking cognizance.
Yes.
The ground that accepting the interpretation, no case is made out. And my lord, while it was listed for admission, my lord, may kindly see my lord's order dated 8/2/2024.
8/2.
Order number 1, my lord. My lord was pleased to take all the materials and has passed the interim order.
Okay.
It's like
Yes, Mr. Vishal, do you have instruction or not?
My lord has considered everything. My lord may see this.
There was some.
All the
exhaustive order.
The judgments I had given, that was also referred. Facts has been referred. And after being convinced, my lord, a detailed order has been passed. Interim order, quoting the judgments, my lord, we see paragraph 6 of the order. Quoted the relevant portions of the Supreme Court judgment, and the judgment delivered by this Honorable Court, reported in Matter 2023, Volume 1, Wheeler 403. Facts have been referred, law has been referred, and
Yes.
Well, OP number 2 has appeared,
but last occasion also he didn't appear. Today also he is not here.
Service is complete. You tell me.
They appeared by them.
already appeared, name has been indicated.
Last occasion also, my lord was pleased to adjourn it because he didn't appear.
What do you say? You, yes. Have you read the order dated 8 February?
I have not known.
That's that. I have written everything there.
Everything.
Judgment, facts, and everything.
Yes. You are serious, protect, sorry. Not now. I am.
Oh, we shall ask. For your benefit, everything is written there. Nothing. Judgment, fact, everything. The last line only I have to change. Quas. That's all. Everything I have written. On the request of Mr. Mishra. Interim order to continue. What do we do it for a call? Next.
68. 68, your lordship.
Interim order.
Interim order.
68, your lordship, record matter to mediation. Successful.
Successfully. Very good.
Mediation report is there. Joint and
Very.
my learned friend is appearing for the opposite part.
I am appearing online, my lord.
I'll dispose it up.
Yes, sir. In terms of the mediation. My lord.
The matter was referred to High Court Mediation Center by the order dated 12/2/2025. On 12/2/2025, this court passed the following order. पूरा 20 order तक उतर pursuant to the aforementioned order, is participated in the mediation process before the High Court Mediation Center. So the mediation became successful. And the High Court Mediation Center, the letter dated 3/4/2025, placed the mediation proceeding before this court. The mediation report dated 3/4/2025 is agenda. Mediation report. Mr. Maharana and Mr. Corida, appearing for the parties, submits that the petition be disposed of in terms of the mediation report. The mediation report as produced above shall form part and parcel of the present order, and the parties are bound to comply their obligation flowing from the mediation report. In terms of the aforementioned mediation report and undertaking given by both the parties to comply the terms of mediation, the present petition is disposed of, and so and so. What is cost?
There is the page 18.
Huh?
There is the page 18.
18.
18.
The prayer made by the petitioner to quash. What are you seeking? Quashing of what?
If I'm 343 dated 24/11/2000. Page 18 I have quoted.
Prayer made by the petitioner seeking quashing of FIR number 3. Which FIR? PS case number?
PS is
Mohanga.
343 minutes.
Mohanga PS case number 343 of 2022. Registered against the petitioner, admissions of opposite party. Number 2. And the consequential proceedings arising therefrom are quashed. Yes.
Urgent copy.
Highly obliged, yours.
69. 69, my lords.
But here is an unfortunate case, madam. Here the only case is that the present petitioner, who is the accused, went to the of the deceased, my lords, to buy a ghee. And it was printed 180. He said, I will give you 140. Other shopkeepers are giving it at 140. There was an altercation and the shopkeeper had a cardiac problem and he passed away. But the police registered a FIR. It's a case of 302. My lords may see the external injury, my lords. Injury report is at page 21. Page 21. External injury is a bruise on the medial side of the left knee joint. And page 22 is the opinion. Death is due to cerebral vascular accident and dilated cardiomyopathy. My lords, in the meantime, my lords, this is a FIR of March 2024. In the meantime, the Zonal IG conducted a supervision and the Zonal IG said it cannot be a case of 302 and gave a report to the IO. It at best, it can be a case of 304A. Incident as a, but till date, they are not filing the charge sheet. That is why, my lords, the case has been given. Yes. Lords is ordered for up-to-date case diary, my lords.
We have obtained the case diary now. But the charge sheet is not there, case diary is there. 6 statements are there. The eyewitnesses are there.
And he only took him to the hospital. He only took him to the hospital, my lords.
They all stated that we have seen that he pushed the deceased and thereafter he died. First assaulted, thereafter pushed, thereafter died.
Where is that IG report? What you are saying?
It should be government, my lords. There was a supervision, my lords. I was called, my lords.
There was a supervision report
by the Zonal IG, my lords.
I will obtain that question. Case diary, we have all the 161 statement I will get. All
you have not filed the charge sheet. Zonal IG says something. Yes. Are you going to file the charge sheet or not? That's the question. Charge sheet 302.
Yes, sir. I will take instruction.
Mr. Mahanti for the petitioner. Submit that the Zonal IG, Zonal IG. Zonal IG police has conducted the internal inquiry in the present matter.
Supervision.
Internal supervision of the entire case. The petitioner was also called for the same and asked the IO of the and please directed the IO to take into consideration the report and find charges of the final point. Mr. Vishwal, the counsel for the state submits that he has no instruction in that way. Leave the matter after 1 week to obtain instruction in that matter. Yes.
Interim protection of any kind in the meantime.
What protection? Now nothing is happening.
70. May I please not speak now? Please, may only putting that matter to lost it. Then thereafter also time and again for production 164.
Yes. Yes. We have 164.
164. Statement अच्छी की देखो तो नहीं रात तरह से ही भूल गए इधर case now the 363 or else.
What is the age of the boy?
But they are married and your also was already filed of your uncle. Fired and blessed his child. All these things have been dealt with by a lot. Only 160.
Do you have or not?
Yes, sir.
Read it to you. You can't prepare the case here.
Yes, sir. I go. ମୁଁ ଆଜି ଏଠାରେ ଉପସ୍ଥିତି ହୋଇ ଏହି ସତ୍ୟ ବୟାନ ଦେଉଅଛି ଯେ 25/2/2020 କାହାକୁ ନ କହି ମୁଁ ବାଲେଶ୍ୱରର ଜଣେ ରିଲେଟିଭଙ୍କ ଘରକୁ ପଳାଇ ଯାଉଥିଲି। ତାପରେ ମାମୁଁ ଥାନାରେ ଏଫଆଇଆର ଦେଇଥିଲି। ତାପରେ ଗତକାଲି ପୋଲିସ ମୋତେ ଘରକୁ ଆଣିଲେ। ଏବେ ମୁଁ ବାହା ହୋଇଥିବାରୁ ମୁଁ ମୋର ଶାଶୁଘର ପଦ୍ମପୁର ରହିବାକୁ ଇଚ୍ଛୁକ। ଏଥିରେ ଅନ୍ୟ କୌଣସି କାରଣ ନାହିଁ।
Right. But do you have my judgment, the recent judgment?
Yeah, Fayadin, Rosaline and Fayadin, both judgment.
Give me that.
Right now, the Rosaline is with me.
And the other one where I distinguish that Ramjilal.
Yeah.
Where is that?
Ramjilal is with me.
I have distinguished Ramjilal.
Yes, that is
Where is
Fayadin.
that?
That is Fayadin. That judgment.
Please give me that judgment.
Yes, I will give.
Reason for public party number 2. FIR number so came to
That is reported also.
The petitioner. Allegation against the petitioner so. You have filed an affidavit for
Yes, yes,
where is that?
uncle.
Uncle's affidavit. Informant is uncle.
Informant is uncle. Copy number 2.
The allegation also. The where is the charge sheet? Where is the charge sheet? Charge sheet.
Yes.
When the charge sheet is filed?
No, she can.
Not there. Charge sheet is not here. Charge sheet is not here. Do you have the idea when that charge sheet is filed or not?
Charge sheet has not filed. For my instruction, charge sheet has not filed, but they can say better.
They can't say anything. That's the problem. Have you made a averment that charge sheet has not been filed?
Yes, that's it. Only investigation.
The the present case is still going on. The statement of the victim has been recovered under section 164 CRPC. She in her statement inter stated as under. Meantime, the before marriage is this the marriage proof is this, huh?
Yes.
In the meantime, the petitioner number 1 and the victim opposite party number victim has already married. Are they blessed with a child?
Hello?
Are they blessed with child? No.
Oh, blessed child. Child document is there.
Where is that?
Lord, page 23. Lord.
23.
23. Yan Sudas.
Okay. They entered into wedlock, and out of the wedlock, there will be child born. There is a child born out of the wedlock. To prove towards the proof of marriage and the birth of the child out of the wedlock, the petitioner has placed on record an excess as an excess 2 series. So affidavit, marriage proof, and various photographs. The parties are claiming to have settled the dispute and to dispute and to prove the claim of the settlement. They have filed many documents. On the ground of settlement, the petitions are taking the watching up for the entire criminal prosecution initiated against party number 2. The opposite party number 2 is the uncle of the victim, has also filed an affidavit before this court. Correct. Are they present? Their presence,
Recently,
their presence is exempted?
not, now they are staying at Bangalore.
Have I exempted their presence?
Yes, yes, they were present, your lordship has exempted their personal.
And the
All of them were
opposite party number 2 has filed an affidavit. Dated affidavit of flag C, entry agent 22/6. The sorry 47. When have we exempted? When I have exempted?
Yes, my lord. Previous order.
Which order?
What?
Which order?
Yes. Sorry.
Which order?
Order I have to verify.
Is a settlement, both the accused and informant has to be there.
Both, my lord, your lordship, pursuant to your lordship direction, they were directed.
Which order I am asking that?
I will verify from the letter.
I have not said that their personal appearance is exempted. I have not said that.
Not exempted. On Passover, I'll give the details.
I have not said that.
But
they have to appear. I will draft the order. I have already drafted the order.
Well,
I'll put it tomorrow and bring them.
Tomorrow, I'll give the details.
This court, the order before the time, which one appearing for the state, and produce the CD, and there is the CD, and the document is before the court. The appeals from the record, but the investigation of the case is still going on, and the parties have settled their dispute. The victim was already married with the petitioner and blessed with a child. Given the facts in hand, the case of the Honorable Supreme Court in Ramvilal so is distributed. Rather, the case of the petitioner is covered by the judgment of this in that judgment. Somebody will or something. And regarding the judgment has regard taking into the developments which will unfold in the present case, and the fact that the justice is not verified. I am of the defensive review that the case of the present case covered by the judgment of this court and also the judgment of the Supreme Court in Grantham and so on so forth. This part. Okay, please see tomorrow. Simply see tomorrow. Yes. Yes.
71.
And bring them. I have drafted already. Yes. Yes.
Item 71, my lords. I have two prayers, my lords. My lords, the matter may be taken some other day, and in the meantime, my lords, the matter may be placed for mediation because the matter arises out of a matrimonial dispute between the parties. 498 and 406 and
notice was issued. Whatever service.
One Mr. Mishra has appeared, my lords, in this case.
Notice was issued to opposite party number 2. Although entered appearance, but none appears for victim. Mr. Raut and counsel for the petitioner submits that the dispute being materially dispute, the same can be settled through mediation. Accordingly, High Court. High Court mediation?
My lords, Orissa High Court mediation, my lords.
Awaiting mediation report.
72.
Please, lords. In this case, my lord, petition is the teacher, my lord. The allegation against her, she was produced to her B.Ed certificate at the time of selection. That is why, my lord, service was disengaged from service. Thereafter, time and again, the university was intimated to the concerned BO, my lord, stating that the certificates are genuine.
So, where have you got that?
Thereafter, what happened, my lord, by virtue of that letter, the DO reinstated the petitioner service. Petitioner is continuing as teacher, my lord.
But criminal case is going on.
Criminal case.
Where is that? Show me. Genuine.
Lords, you can have a glance, my lord. And next of 5, lords, you can have a page 15.
5, huh? Yes.
Petitioner name is Subhashini Das. Subhashini Das. Page 15, my lord. Serial number 3, left side. Subhashini Das.
No, Subhashini Das. Number 3.
Number 3, my lord.
Yes.
Pass correct and genuine.
Correct and genuine.
And thereafter, and it's just 6. But you can have a glance.
Yes.
Another letter was written to the district project coordinator by the examination, stating therein the certificates are genuine.
Yes.
The letter
and annexure 7 you have been reinstated.
My lord. And the 7 reinstated, sorry. Recently they were reinstated. The lordship last time, my lord, on 22nd, my lord, January, directed to the council, government council to take instruction in that regard.
Yes.
It is also stated that after verification, it is found to be true case against the accused person, Subhashini Das. So the page
27. Yes.
Inside of the charge. Page 27.
Yeah, what is the meaning of it? What is the meaning of this sentence?
Verification of this activity of the accused Subhashini Das from so university, it is found to be true case.
What is found to be true case? Verification. What is the verification? Verification is the certificates are genuine. Genuine. Then what is he writing? On verification of Bundelkhand University, it is found to be true. What is true? Certificates are true. What language?
Found to be true.
True.
Case under section so and so.
If the certificates are true, where is the question of 420 What kind of charge sheet is this? You read the sentence completely, loudly, and make out a meaning of it.
During investigation of the case from the statement of complainant and other witness, verification certificate and mark sheet of the accused so and so from university, it is found to be true. True case under section so and so against accused person.
It is found to be true what? True certificate or true 420? What kind of
certificate? True certificate.
You tell me what is your instruction? How 420, 468 is made out if true.
Yes.
And you have reinstated, your government has reinstated him.
Yes.
What about the other cases?
Same,
Same.
all the cases.
Shall I record your this thing? That certificates are true. Some Bundelkhand certificate, whatever, I don't know. And you acted upon that, gave them the job. And still you will continue with the criminal case. What is this?
That's it also 3-4 lines.
The charge sheet is nothing. Charge sheet is nothing. I'll reserve the judgment. To file written note. Written note. I'll quash it. How many matters?
8 matters.
8 matters. All the 8 matters, judgment reserve. You file written note. Argument heard, judgment reserve. The state council is, the parties are granted liberty to file written note of for submission within 3 days. Within 3 days. Give it. Otherwise, it will go on and on and on. There is no end to it. Yes.
My lord, one of the cases.
Total how many cases here?
8 cases.
8 cases.
My lord, one of
In
the,
all the 8 cases, you have to prepare a chart and give. Otherwise, see, on the basis of the facts of first case, I have to decide.
Yes.
All the 8 cases, wherever there is a genuine certificate according to the verification, where you have given the job that, and prepare a chart and give. Okay.
my lord, one of the, out of the 8 cases, my lord, serial MC number 2243 or 24, even the certificates are genuine, that is intimation of the university, but she has not been given
Okay, let
employment.
him prepare a chart and give.
Employment not given.
That we'll see.
One case. Other cases, they are continuing.
Let him give the chart. Yes, yes.
73.
Interim order may continue. Till deliver of judgment. All right.
May it please, sir.
Yes.
Service dispute of a disgruntled employee snowballing into a criminal case. Now, this lady was employed in the bank, and she had taken advance during COVID. So she contracted COVID, remained absent for 1 month and
10 seconds. Our visit is really easy only. Right, no. इसी का काम को तो सब काम करो ठीक है नहीं सबको इसी का और एशियन कर दो परमानेंट कौन को नहीं that's it अब फाड़ देना है ना तो खुली हो गई tomorrow it will be done. They've closed that AC side. It's very.
No, we never complain.
So because of no problem is if the fans are working, it's very difficult to hear also. कल ही डाउन करें आज ही कोई हुआ yes.
She contracted COVID, remained absent for 1 month and 15 days, then she joined back. During the COVID, she had taken a 10,000 rupees advance from the bank. She joins back, works for another 15-20 days.
What was she?
Field agents.
Okay.
Field agent. Then she abruptly pays back, said, I want to resign. And then the managerial staff, they say that you pay back your 10,000, that's the part of your contract notice period, and also 1 month notice period. You have to give us at least 1 month notice. COVID, your lordship knows there was a scarcity of employees everywhere. At least give us the 1 month notice period and then you leave. And you pay back the 10,000 because we can't take it on our risk. She does not do that, refuses to do that, and threatens that I will take you to the police. Only then you will be in a position to give me the release letter. That is exactly what the FIR is at page 56, Annexure 5. That is exactly. And in fact, offense is even more interesting. offenses under 294, 354A is the principal offense. 506, 34 and 294, my lords, 354A. One of the accused is a lady who stays in Bombay. HR manager is not even there. And my lord, all the 161 statements at parrot line that she has come, asked for a release letter which was not given, and then she closes the office door in a huff, does not allow anybody to get in, and threatens them in a loud voice that I will go to police and I will make you give me the release letter. And then this is the FIR. And in fact, and I will immolate myself and commit suicide. So therefore, the managerial staff they lodge a FIR in the police station that this is
threatening and all.
Threatening and all that. As a counter blast, thereafter, after like 5 or 7 days of that incident,
yes,
she, my lords, in a different thana, she has given a FIR, and these are the offences. And one of
the incident has taken place on 18/8/2021.
My lord.
And where is the complaint against you now?
Thana is
Your FIR
Town Police Balusur.
against you.
Against police.
Yes, Town Police.
Kindly go to
Yes.
my lord.
That is Annexure 3. Against you, it is Annexure 3.
And against me is annexure.
Which is you seek quashing of that.
Man, your lordship, kindly come to the page 56. This,
Yes.
translated version of the FIR, page 53, annexure 5.
Yes.
Informant Revati Naik, so. Police station, here at the police station, giving a written complaint to you that I have been working as a relationship officer at Sujata Small Finance Bank at Balasur Bank. Last month, I was COVID positive. After 15 days again, I was COVID positive. I received the salary for the month May. The salary for the month June has not been given as I was on leave. The company has given me 10,000 as advance during my illness. I didn't work during the notice period because due to illness, it was difficult for me to do field work. Thereafter, therefore, I sent an application of my resignation to our company's HR office, Subrat Panda. My branch manager, Karunakar Mishra, my section number 1, is not accepting my resignation. Due to which, when I go for interview to other company, they ask to bring clearance letter.
Yes.
I have asked for clearance certificate to the branch manager, Karunakar Mishra, and HR Subrat Panda. They said they can't do anything. I have intimated the same to the head office through mail. They said that they will process the exit when I clear the advance salary, but didn't do. I again tried to contact Mr. Branch Manager, Karunakar Mishra, HR Subrat Panda, HR Seneca, HR Head Office, Seneca D'Souza, who's in Bombay, the lady. Through mobile, but they didn't answer. So I contacted them from my BD's phone. I requested them not to play with my future, otherwise I'll be compelled to ablaze myself. This was the trigger for our FIR. But it is sad that HR Subrat Panda, Karunakar Mishra has made a complaint against me at town police station that Revati Naik will commit suicide. Police officer compromised the matter by calling all of us and asked us to give clearance to me. Next day, our area manager called me and said that he will do the clearance next day, but I have not received any clearance till date. They have given physical torture as well as mental harassment to me. There is no background of that. Abruptly, this statement has been made. Every day in the evening, BM Karunakar Mishra and area manager Niyakar Sav asked me to visit field in the name of work with wrong intention. As I refused for physical relationship, they are now harassing me. This also statement has been just.
You are sending to field. Where is the question of physical relationship in the field? You will call him to your house or somewhere. Not that you will send some
for physical and this statement has been thrown in to give strength to the.
Who is appearing for the
that is more interesting. We had your lordship and evinced it had fallen from your lordship. That why don't you try? We went with the compromise letter, the clearance letter, and I filed an affidavit to that. I think that in your lordship record. We went perhaps on 20 on 21 on 20, 21, 25 minutes we filed the affidavit.
Yes.
We went to her village, she along with her father, and I'm just reading that portion of the affidavit. As per the High Court direction, this, that para 3, that this Honorable High Court in 7/1/25 directed the petitioner to take summons to Dasti for serving it on opposite party number 3, Ms. Liberty Naik, and file service memo to that effect. Then as per the Honorable High Court direction dated 14/1/25, I, along with advocates clerk Mr. Prasanta Kumar Manki, visited the address of opposite party number 2, Mr. Korunakar, with Mr. Sankar Mishra, Niyakar Saul, and Subrat Panda, who are petitioners 1, 2, and 3. In fourth is that lady. In order to avoid any unwarranted situation, the above mentioned petitioner was waiting outside the village. That I, along with Mr. Prasanta Kumar Manki, visited the house of OP number 2 at Sibo, PS Basudevpur district, Bhadrak, and requested her to receive the notice and stated the facts about criminal miscase. The opposite party number 2, along with her father, Mr. Ajay Kumar Naik, refused to receive the notice, and upon our repeated request to receive the same, they abused us and asked us to leave their house. We apprehended an unwarranted situation and intimated the police control room for assistance. That one person named
You have to serve,
Chintamani Naik,
I should go and serve.
who identified himself as Sarpanch of Sugo Grand Panchayat, acknowledged our visit on the backside of the notice by endorsing it to seal and signature. In the meantime, PCR from Basudevpur came, PS came, and after apprising the situation, they recorded the details. And we left without the notice being served, as OP number 2 refused to receive the same. Thereafter, your lordship, the law officer has filed the affidavit. Thereafter, my lords, your lordship passed an order on 21/1/25, treating the submittal sufficient. And your lordship had said that we'll wait for the next date. If she doesn't appear, then we'll dispose it.
Okay.
That is
Service of opposite party is taken to be sufficient.
Bhajanlal, 3, 5, and 7 is the case.
Yes, what do you say?
Bhajanlal exception 3, 5, and 7. That's the case. Clear-cut case is being made out.
Through IAC, last chance may be given.
No, see, I have recorded that it is sufficient because of the reason they went to serve Dasti and they created a problem. And PCR went
also
and recorded everything.
Everything was written.
Then why should the IAC will go now? In the PCR when everything is recorded, then service is sufficient.
Exception 3, 5, and 7 of Bhajanlal minutes are clear. And all the 161 statements, I'll just read one as a sample. I'll take a lordship, page 60, statement of Subhasri Dej.
Yes.
I hereby state before you that I am now working in Suryodaya small branch at small finance branch at Baleswar branch. During last COVID, Rebati Naik was also working in this bank. At that time, she was detected COVID positive. And for that, she took 10,000 as advance. After recovering from COVID, she visited the office and gave a resignation. As per the rules of the bank, she had been given 1 month time. But she came to the branch and started arguing with the branch manager to accept her resignation and to give her clearance. The branch manager tried to make her understand that there are some rules of the bank, and without getting approval from the headquarters, clearance cannot be given. After this, Rebati Naik in anger closed down the shutter of the office and did not allow anyone to come out from the office, and in a loud voice stated that I will go to the police and do case against you, then only you will give clearance to me. Then she opened the shutter and left. And this is the parrot-like statement in all the my lord's statements. This is the narration in all the statements, 161 statement. And also, my lords, the
and page 62, her statement.
Well, 62.
Same as copy.
Her statement.
What she says.
It's a facsimile of whatever she has stated earlier in the affair. It's a facsimile, virtually a facsimile of the affair. And then all that has been seized, resignation letter and appointment letter by the police. No call details, nothing.
So even in her statement in 62, if you see, the story is different.
They are giving.
No, no, wrong intention, up to physical relationship, they are not harassing, they gave me threatening that if you don't agree, we will kill you. My life is in danger, my health condition was not completely good as I suffered from COVID, they gave me physical and mental torture. During this illness, I have visited the office several times and gave me mental torture by calling me to police station. They also assured to give clearance within 24 hours in front of the police. Same thing.
Every day,
Same thing.
Where is
every day in the evening, BM Hon'Ble Mishra and the area manager Director Sahu asked me for visit field in the name of what?
What?
With wrong intention.
Intention as a
And
refuse of
as I
physical
refuse to physical relation,
Same as
they
that.
are now harassing.
They are asking you to go to field. She is working, she will go obviously. There is nothing here. And where is the independent witness? And that one witness which he read it out, that what is her name? Subhasri Bez. She is independent witness. What she says?
Yes, sir.
What she says? Except her statement, who herself is indulged in this thing and they have filed a case against her. Except her statement, what evidence else you have? Any other 161 statement? Except the victim statement, so-called victim statement.
Not a single.
What else? What else you have?
Not a single statement. One Urvashi Sahu.
Where is that? Page?
Page 50.
50.
58.
58.
We have stated that before I also Rebecca was working in this branch. At that time, she was detected COVID. For that,
It's the same as Subhasri.
after recovery.
Your case is what?
Same as Subhasri.
If he says that she came, the so-called victim came and started arguing with everybody.
Closed the shutter, did not allow anyone to come out. And in a loud voice stated that I will go to the police and do case against you, only then you will give me clearance. Then she opened the shutter.
What else you have? All independent witnesses have not supported you. Except her own statement. Her own statement is doubtful.
Yes.
Because she herself indulged and there is a case against her. Just check it up. Anything else? Anything else? Urvashi Sahu and Subhasri Bez. Thereafter, Subrata Ponda. He is one of the accused. Forget about him. Accused. Then come to space 61. Soneka. She is also an accused. Forget her statement.
Soneka Troy is 4. She stays in Bombay.
Huh.
She is posted in Bombay.
Pratap Kumar Sahu. Who is he? 63.
I am working in Suryadev Bank at Balesar branch. One is group finance, the other
He
is
told that as I worked in field, it is impossible.
There is
for me
nothing.
to do all this.
He is also saying nothing.
nothing.
And what else? Aluka Kumar Das.
He is a Caesar witness.
Malay Kumar Bala. Just see 65, page 65.
65,
Read it. Read it.
I am not.
He is also an
fully
independent
aware- I am not fully aware about what dispute has been happening between them. But I can say that in the month of May, Rebati Naik had not come to bank due to COVID because she was detected COVID positive. So she borrowed 10,000 rupees as
In advance.
advance from the bank for her treatment. She could not go to field during that time. After recovering, she gave her resignation to HR Subrat. But Hon'Ble Mishra, HR Subrat Panda did not accept her resignation. In this regard, Rebati Naik has visited bank several times, asked clearance. By not getting, she informed about the matter to the police. Police came for investigation. On that day, I called HR Panda, Babu,
What is that?
Hon'Ble Mishra, Nirakar Sahu to inform the same, but their phones were switched off.
What is there? What is he says? These facts are not disputed. 10,000 rupees advance was taken.
That is.
And when she came back, the bank said that you deposit back 10,000 so that clearance we will give. That is the reason this Hrushikesh Mishra, whoever it is, Karunakar Mishra and Subrata Panda, they refused to give the clearance.
Yes.
Therefore, there was a misunderstanding. Where is the 354? Where is outraging modesty? Merely because 10,000 rupees advance was taken by her, asking back by the bank officer, 354.
Other witnesses have same line.
Manas Rana also same, 67.
None of them have said anything.
Not a single statement.
Yes. Anything else? Want to add anything?
No.
See, the complainant is not there. Responsibility is yours now. You have to say whatever. Tomorrow it shouldn't be that the complainant was not heard. Enough attempt was made to serve complainant. Complainant didn't come. Even Dosti notice.
21 January 2025 already notice made sufficient.
So I pass the order. Okay. आप ये कॉपी है हार्ड कॉपी है होगा ये सर पास
Do we need to file now? Short note?
if you want to file short note you can file it within 2 days. Don't delay it, otherwise you'll forget it and then it will go.
That mistake will not.
Yes.
2 days.
Within 2 days.
Yes.
That matter also. The earlier matter also.
Grateful, man.
Yes.
74. My lord, I am appearing for respondent number 2. I seek an adjournment.
Respondent number 2.
Opposite
is appearing.
wife. It is a matrimonial dispute, my lordship.
Matrimonial dispute, my lord. No allegation on the face of the material. The application of discharge filed rejected. My lord sent it to
Mediation.
petition failed. No response from the other side. My learned friend is appearing. I have no problem. I'm prepared.
He's seeking an adjournment.
Adjournment?
Yeah.
I didn't.
Yes, that's what. Yes, Mr. Pradhan. What exactly you want?
An adjournment may be granted.
Adjournment may be granted.
I thought that you were.
On behalf.
Happened, my lord. He may be, if he wants to file a response, he must file a
That's what
response.
I'm going.
That may be.
Mr. Ramesh Chandra Pradhan, learned counsel, appearing for the opposite party number 2, seeks an adjournment to file response to the petition. Let him do so within a week. This matter was sent for mediation. However, the mediation report dated 4/1/2025 indicates that the mediation has become unsuccessful. Leaves the matter for final hearing, and the interim order passed earlier are continued. Further order. Let him give after 2 weeks. They will play.
Very short matter, my lord.
Matrimonial dispute. Yes.
75.
May it please your lordship, my lord. I am VCR Puri, my lord. In your lordship was already admitted the case notice already solved with the opposite party number 2, who is the own uncle of the present petitioner, my lord. As per instruction of my petitioners, my lord, the amicable settlement is also arrived between the parties. That is the family.
It is incorrect. But I am appearing for the informant, my lord. Regarding settlement, it is incorrect fact, my lord.
No. See, the counsel appearing for informant says that there is no settlement at all.
There is no question of settlement.
Then, my lord, this is the relationship between the uncle as well as the present.
Whatever he says, no settlement.
So matter may be hard on merit, or he may be filed to respond, my lord, to this.
You entered appearance for opposition?
Yes, I have entered appearance.
Already entered?
Already, my lord, entered appearance.
So already entered appearance for opposite party number 2. Leaves the matter for final disposal. Yes. The counsel for the petition submits that the matter has already been settled. However, the counsel appearing for opposite party number 2 disputes the same. Therefore, leaves the matter for final disposal.
76.
The lordship may kept it.
Give it.
Date taken. Date taken. For it.
76. Are you appealing?
My lord, I am for the opposite party, Lordship.
Lordship, I am appearing on behalf of Mr. AP Bose. Lordship, I am praying for an adjournment.
You also. Joint
Lordship,
request.
the interim order may continue.
Joint request adjourn, interim order continue. Yes.
Lordship, the interim order may continue.
Oblige.
Very pleased, Lordship. Chairman, the petitioner seeks to passing of the entire criminal proceeding against her. Petitioner is a staff nurse, my lord. While working as such, she gave saline to a patient, and after giving 2 salines, when she gave the 3rd saline, she felt unconscious. Then doctor came, and thereafter the allegation was made that due to negligence, the FIR has been registered. And departmental proceeding was also initiated against the petitioner, and thereafter the petitioner was suspended, and also departmental proceeding, she has been exonerated from the charges and reinstated, and thereafter retired. And the informant, opposite part number 2, had also filed a consumer case against the petitioner that has also been dismissed. So now
Non-prosecution.
the petitioner is not getting her pension due to pendency of this criminal
That's
proceeding.
not the ground. Not getting pension doesn't mean that you will cause. What are the materials just stated?
That tells means all the offences are available in nature, and the allegations do not make out any prima facie case
Show me that.
against the petitioner.
The rest of the thing, whatever you have said, is irrelevant.
Because the petitioner has no fault, because after the doctor came.
What is the stage now?
Now one witness out of 14 charge-sheeted witnesses, one witness has been examined since 2022 January, and other witnesses are not coming up. That is why the
I'll expedite the trial. 2013 matter.
Your estimate can also cross because
See, trial is going on. At this stage, I can't do it.
Trial
2013 FIR, you are coming now for causing.
After 1 year, no witnesses are coming up.
So therefore, I'll give a direction to the trial court to expedite the trial.
Because
That's the only thing I can do.
cover decision is also there. Your RC may also.
The 2013 FIR, you are coming now. Evidence is being recorded. At this stage, how can I interfere?
Only one witness has been. Others are not coming. They will not come also, my lord. And I am not getting my pensional benefits. And I am also, in the meantime, more than 71 years old, my lord.
Whatever, sir, you try to appreciate one thing. FIR is 2013.
Yes.
Charge sheet is filed 2013. You didn't do anything. Now, when the evidences are going on, and you came for quashing of FIR.
After examination in the department of proceeding, I come.
That is not a ground.
Because
That's not a ground.
there is a decision of this honorable court, my lord, division bench.
This I have distinguished already. Pani, I have already discussed. This will not help you.
Because after examination, the disciplinary proceeding.
Disciplinary proceeding, he was exonerated on 2014, my lordship.
I know, I've seen it. I've seen it.
25.
That will not help you. Minakatan Pani will not help you. That's a different case altogether. Division bench of this court, it says that departmental proceeding exonerated, you can be exonerated in the discharge in the criminal case. But in that case, the exoneration of departmental proceeding has been scrutinized judicially. This went up to Supreme Court. Supreme Court upheld. On that basis, division bench of this court said it can be quashed, which and relying upon Radhesham Kejriwal. Radhesham Kejriwal is regarding the adjudication proceeding, not departmental proceeding. There is a vital difference between adjudication proceeding and departmental proceeding. That's the distinction. So therefore, Minakatan will not help you. Better I'll give a direction to conclude the trial within 6 months.
My lord.
Because 2013 matter,
Yes, yes.
2014 charge sheet is filed one, you are unnecessary suffering. Okay, right. Petition is one of the accused in FIR number Kumbharpada PS case number 357 of 2013, registered against him for alleged commission of offence under section 284 of 337 and 34 IBC. After investigation, charge sheet in the present case has been filed on 28/12/2013, and cognizance of the offence is also being taken on cognizance cover. When the cognizance is taken, सब कुछ लिखते हैं.
Not filing.
Any idea? When the charge is framed?
My lord,
Do
only
you have any idea?
one witness has been examined as.
I'm asking something else.
Cognizance.
When cognizance is taken,
No,
when the charge is framed?
No, my lord.
They have not filed. My lord.
In the petition, have you said anywhere anything? When the charge sheet is filed, I got it.
Charge sheet.
Charge sheet I have annexed, my lord.
It's all right when the charge is framed again. Nothing is written. Right? And you also draft such a petition vaguely without any this thing. I am also passing those kind of order. What to do? No particulars, nothing. When the charge is framed, at least I should know. Sheet 2013 is the charge sheet file. 28/12/2013. When the charge is framed in this case. You are absconding?
No, my lord.
Then why so late? Do you have any idea?
No, my lordship.
If you, the question is if he was absconding, if at all,
Yes.
he was absconding from 2013 to whatever 2024, then he is not entitled to get an expeditious hearing.
Yes, my lordship. Because my lordship.
Therefore, I am venturing into all this.
I am working as a nurse, my lord, because I have reinstated in the
I'll get it. Please tell me.
I was placed under suspension.
If the
thereafter-
charge is framed long back, I can understand. It may be a case where you are absconding. How do I know? You abscond for 10 years, thereafter come to the court and take an order like this. It sends a very bad message.
My lordship.
Sir, yes.
Kindly have a glance to Annex 4, my lordship, page
Yes.
number 22.
Yes.
In consumer court also he has
Consumer.
filed, but he has not appeared in the consumer court.
A dismiss in default. I
Yes,
think
my
that-
lordship.
The consumer
That's not
court.
an issue.
Yes.
Issue is whether he was diligently participating in the proceedings.
Yes.
My lord, I will obtain.
Can you get information? And sir, I put it day after.
I will obtain instruction, my lord. I
You
will
get
obtain
the
instruction.
information whether
Yes, ma'am.
you day after the court. Day after. Get the information when the charge was framed. Okay. 11 पे रखो 11 पे नहीं 11 पे रखो 11 yes
78. May I pick up the second case I have?
yes
The present case is arising out of a matrimonial dispute, your lordship. So for a moment, your lordship, kindly come to the FIR was registered arising out of the complaint, your lordship. For a moment, your lordship, kindly come to
the first matter you are talking about the second matter.
second matter. I am appearing the second matter. I am the in-law.
Two application related to the same case. One, informant is filed for early disposal. The other, the accused is filed challenging the order of cognizance.
Okay. Second one is yours.
Yes, my friend is appearing for the.
I am appearing in the second.
When I am
case,
for the
Lordship.
informant.
Yes.
The petitioners are in-laws, father-in-law and mother-in-law. Unnecessarily, they have entangled in the present FIR, Your Lordship. And if Your Lordship kindly come to page 13 for a moment.
13, 1-3.
One. Your Lordship.
Yes.
The marriage was solemnized in the year 2018, and out of that wedlock, one child was begotten, Your Lordship, in the year 2019. And the present opposite party number 2 did not reside with the husband of the petition, husband, Your Lordship, and only to satisfy his personal grudge, Your Lordship, against the husband, now he has entangled the father-in-law and mother-in-law in the present case, Your Lordship.
Let's see what are the allegations against you.
Yes, Lord. Then Your Lordship kindly come to the page 13, Lord.
Yes.
Next para, third para, Your Lordship.
Yes.
एक ही बापा घर आम्ही
स्वामी मौजूद middle of it, huh?
in-laws.
Yeah.
एक ही बाप घरे बाप घर परे बाहागर परे आम्भे मुदेया मो स्वामी शाशु शशुरଙ୍କ ସହିତ ଏକ ମାସ ଭଲରେ ଅରକ୍ଷିତ ବିଶ୍ୱାଳ ସ୍ୱାଧୀନ କଲିନି ଶଚାଂଶ ଭଡା ଘରେ ରହୁଥିଲୁ। ତାପରେ ମୋ ସ୍ୱାମୀଙ୍କର ଚାକିରି ସ୍ଥଳ ବାଙ୍ଗାଲୋରରେ ହୋଇଯିବା ପରେ ଆମ୍ଭେ ମୁଦେୟା ଆମ୍ଭ ଶାଶୁ ଓ ଶଶୁରଙ୍କ ସହିତ ଘରେ ରହିଥିଲୁ। ଆମ୍ଭ ସ୍ୱାମୀଙ୍କ ଔରସରୁ ଗତ ତା ଶଚାଂଶ ରିଖରେ ଏକ ପୁତ୍ର ଜନ୍ମ କରିଥିଲୁ। ପୁତ୍ରର ଜନ୍ମ ପରେ ମୋର ସ୍ୱାମୀ ଶାଶୁ ଶ୍ୱଶୁର ଯୌତୁକ ବାବଦକୁ ଅଧିକ 5 ଲକ୍ଷ ଟଙ୍କା ଦାବି କରି ମତେ ଶାରୀରିକ ମାନସିକ ନିର୍ଯାତନା ଦେବା ଆରମ୍ଭ କଲେ। Normally, immediately after the born of the child, no one claims the dowry.
Let us come to the
Yes, I'm just clarifying. दाबी कर
against you package, full package. 5-6 cases ka one package.
Yes.
And you have to suffer. You married, then you suffer.
Yes.
That's the only thing I can tell you.
Kindly come to that affair, second affair.
I'll expedite the trial.
I let me complete. Then whatever Your Lordship pass, I will oblige.
Yes.
Let me complete.
Yes.
Another affair was the occurrence was took place in the year 2023, Your Lordship.
This is a new affair.
Another affair.
Oh, no.
Yes, let me come.
Give me copy.
More do.
498 again.
Again 498, and that was registered in the year 2025 under IPC. Many surprise things, Your Lordship. May I permit you to read the second affair?
No, before registration of this affair,
already this has been
Mr.
registered.
Chan's client might not have taken advice from him. He would have advised something else.
I don't have any instruction.
Yes, already this has been registered, and
yes, Mr. Chand, what do you say?
I don't have any instruction.
Same 498 once again.
Because I don't have any instruction.
And I am relying on
Let my
judgment
friend
of
give me
Dara Lakshmi.
copy. And my lord, with all
But
that,
Dara Lakshmi Narayan, that is double.
In any case, even if I pass one FIR, the other one will remain.
I am the in-law, Your Lordship. I am the father and mother. I have known it is only the FIR. Nothing has been spelled till date. No proceeding has been conducted. Not the lady is not deposing his evidence. Whereas the priest.
Is there any chance of settlement?
No, my lordship. I have taken the instruction. There is very. I am heavily relying on that Dara Lakshmi Narayan.
I have no instruction, but if my lord asks, because always it should be welcome.
I want to try. See, there are 2 FIR unnecessary, and now
and she is residing with her parents since 2020. As per his own statement, she is residing with her parents since 2020. And we are in 2025. How the cruelty is made out against the husband?
You try for where will you go? High Court or anywhere else?
My
District Court, you tell me. Khurda, na?
Khurda.
Yes. So you come to High Court. High Court Mediation Center will be a bit.
Your Lordship, if you will direct accordingly, I will. Already I have taken the instruction. He is not willing to go for
Then you suffer. I can't help it.
Because he filed the restitution.
If this
restitution
you tell your client, if you are adamant on that, then I strictly, as per law, if I'll go, I'll have to dismiss it.
Then Your Lordship, Your Lordship, direct accordingly, I will intimate my client. I will advise him to come to the mediation center.
No, you need not, rather you suggest them to go and settle with the issue. Otherwise, see, I'll have to dismiss. There is no way up for me.
Yes, I will suggest my client.
There is a specific allegation against.
I will suggest my client to confirm and mediation.
That's a better idea.
Yes, Lordship. Yes, I will suggest. I will try my level best.
Dispute is arising out of a matrimonial discord. Hence, I am of the considered view that the petitioner parties could explore the possibility of a settlement through mediation. Hence, the matter is referred to High Court Mediation Center, so and so, and so and so. Both the Mr. Chand and Mr. What is your name, sir?
Niranjan Naik.
Mr. Niranjan Naik and Mr. Chand, appearing for the parties, are also of the same view. That's the parties can take a chance exploring the possibility of settlement. Awaiting mediation report, leaves the matter also, interim order to continue.
Maybe I'm a lady without the money. Some money may be given to me for the cost.
You have come here for expediency.
No.
In that case, you are asking maintenance.
Without any petition. Because of the fact that I have no income and I have to come.
Rather, you advise your client to file something else instead of filing repeated 498.
No, so, but
I have to pass either. Both the case can't go together.
I am also asking about how the application, this FIR has been entertained also.
I don't know.
Yes. One case.
That's why the moment I saw, I said that your client is not taken.
So, but other offenses are concerned is maintainable because.
Maybe what is this?
No, 7 except the opponent did is 294, 323, 506.
That is also not mental because it is not residing with her.
Or during the pendency, if some overtime has been committed by the husband or the in-laws, it will amount to
investigation.
498. I do consider 498 should not be there. Otherwise, other offenses.
This is not
Abusing process of the court.
But you try. Let us see.
Yes, sir.
If it doesn't happen, we'll see.
Yes, I will try.
79.
Passing of the criminal proceeding, matter my lord compromise. Annexure 2, my lord, page 15, the cognizance order. Offense, my lord, 370. Page annexure 2, page 15.
15.
My lord, that offense, my lord, 376 2FN, my lord. FIR, my lord, filed 5 years after the occurrence. And the affidavit also filed on annexure 4, page 19 by the victim. She clearly stated that, my lord, there was law of affair. And due to national.
164 what?
My lord, 64, my lord, annexure 3. There, my lord. And
let's read what she says.
But she is blessed with a child. Out of the love relationship, she is blessed with a child, my lordship, girl child. And when the 164 statement.
What is this of this?
Yes, my lord, at the time of the occurrence, my lord, 38.
Let it be on Monday, Tuesday, 15. The child is not well. How do you know within one day?
Plus,
So let it be on 15.
Grateful, my lord.
15.
It takes.
Last order you wrote, so you can say 31-1.
31? Yes.
Yes. The detailed order was passed. Fact as well as law. Both the persons you narrated.
Yes.
Yes, my lord. I am for the opposite party. Lord, here the cases to pass the proceeding in question. And the point raised in this petition is that there was cause of actions, and when the cause of action was not there, and there was a delay in filing the complaint in questions. First, and the second thing is cognizance has been taken without due procedure of law. That is the two things they have stated. My humble prayer before the honorable court is taking into consideration the provisions prescribed on 517 of the BNSS. The complaint is within the prescribed period, and regarding cognizance, the very notice which has been issued, that is issued under 223 proviso. No cognizance has been taken by that notice. Rather, a notice has been issued that such a complaint is there. They have to come and appear in the inquiry to find out whether a prima facie case has been made out or not. So when cognizance has not been taken, so it cannot be challenged. Because cognizance has actually been taken on
yes.
2/1/2025 cognizance has already been taken. This is the order
2/1
2/1/25.
20
25.
25. Yes.
And the order dated 6/11/24 clearly speaks. It is a notice under 223 provided.
Have we checked it?
No, I have not seen it. I have not seen it. But whatever everything said and done, I am challenging the whole proceeding itself. Because the very basis of the initiating proceeding is the check. And that proceeding, if is not maintainable, whether cognizance is taken or not, the issuance of process
Just
itself.
check, check it, check the order.
I'll
just check the order. Check the order. Are you going to file a reply?
Yes, sir.
So entered appearance for opposite party number 2 and seeks 1 week time to file reply to the petition. Reach the matter after 1 week. Interim order passed on such and such date. Interim order passed on 31/1/2025 by this court. Yes. Just check it up. What is the
Yes. And you have to pick up date.
Yes, we'll give a date. Yes, yes. 81.
81.
Yes, Mr. Rao. Who is it? You have entered appearance. Okay. After two, so and so entered appearance for opposite party number 2. Yes. And seeks to file response to the petition. Mr. Sahur, learned counsel for the petition submits that the parties have already settled the dispute. Therefore, he seeks a specific date. Date. You did specific date. 30th. 30th.
Obliged. 82.
That matter, my lord.
Where the lordship has asked
The petitioners has absconded, my lordship. They are after release from the hospital, they were not found. That report was given by the IAC, my lordship. Last occasion, and your lordship was simply adjourned and asked for the report regarding to the recent health condition, my lordship.
What is the position now?
regular dialysis.
I think they are interested to spend money on this.
These are by Biju Sasta. They're reimbursed.
The government will spend money on your treatment.
Dithara bypass daily dialysis.
They are interested to spend money. Why are you?
Transplant Transplant. And this much of documents the daughter has said. And the granddaughter committed suicide.
Kidney transplant.
While undergoing that process, he suffered a stroke. 16 January
What is
operated.
the age, by the way?
Age not much.
One is 60 years and
60.
there are two petitioner, my lordship.
Yes.
Father and son. Father and son.
The only problem is you have absconded.
No, not absconded also.
Are you not surrender?
They-
Interim
not-
bail after interim bail.
Yes, I was in hospital, my lord. In fact, this Villa has taken note. Your lordship on also last occasion on 23rd August, he was brought to the court in an ambulance. That is how your lordship has directed. Please reconsider. Because see the plight, someone is attending the court, but thereafter, because of this treatment and heart stroke could not appear, the non-court said you are a flouter.
But on 20,
I don't attribute anything. Record is telltale.
Yes, madam, what do you say?
my lordship,
Sometime-
22/1/2025, they are released from that hospital. But after that, they were not found, my lordship. They may appear before the local.
Not they, only one. No?
No, my
My
lordship.
father and son,
Two of them.
son is supposed to give the kidney, my lord.
Two of them, my lordship.
The only father and son.
Then why, who is, the father is the
Pradeep,
patient or son?
Father is the patient.
patient.
Why the son has not,
On, in fact, at this hospital, there was the
where is the report that the son will give the kidney?
present class.
Because if the father is ill, the son is also taking advantage.
Exactly advantage in the sense, my lord.
I'll
None
give,
else is there.
no, I will give relief to the father, not to the son.
Can the daughter-in-law already left?
Whatever, but see, there was an order, at least he should have gone to the, he's a
35
healthy
years.
boy. Why has he not gone?
No, this is the consideration for which your lordship has said.
It's all right. You get the report that the son is going to give the kidney, then I'll give him also. But to begin with, I'm giving relief to this man
Yes, sir. Yes.
who is undergoing dialysis.
Yes,
Let him see.
Yes.
A person who is undergoing dialysis, why should he be there in jail?
In fact, I was
Let him in.
told he has undergone one bypass. From the entire bunch I got, in 24 also another bypass was. He must be
Terrible
counting
health.
days.
He's Pradeep, huh? What is his name?
Counting days.
Pradeep Das. Pradeep Das. Right. When the interim bail was granted, madam? Sorry, madam. Both of them. Interim bail.
My lordship, 33/2024.
Yes. Order dated.
On 33/24, the accused persons were released on interim bail. 33/2024.
33/24. Okay.
Yes, BLAPL number 1079 of 2023.
1079
And
24.
23, my lordship.
Yes.
And another one is 11625 of 2023.
11625, huh?
Of 2023 for Praveer Das.
Pradeep, huh?
And it is being extended. time to time.
And they were given 3 months, huh?
3 months.
Then again, my lordship, they have to surrender on 1/7/2024.
1724.
But they didn't
But
surrender.
they did not surrender.
No, my lordship.
No. The petitioners.
And last occasion, they have appeared on 24/8.
In this petition, what are you asking?
That refusal of interest. Lastly, they have appeared.
Where is that order of refusal?
Refusal is case 89 starts. Long drawn order. And 91 would be relevant.
91. 91.
91, the last paragraph.
Yes. Yes.
On 24/8/2024, both the accused person appeared in court. Accused Pradeep Das was brought to the court by means of ambulance. The advocate for the accused person stated this Mittal hospital, all these things. Now it was thereafter extended.
But rejected was 24/1/2025. It was rejected, my lordship.
Yes.
But this is the order by which it is you were
Yes.
asked to surrender.
Yes.
Petitioner is agreed by the order dated. This order dated
4/10/2024.
4/10/2024 passed by learned sessions judge, learned additional district and sessions judge Umar Court in TR case number 32/4/2022, directing the present petitioner to appear and issued eligible against the petitioner for 6/11/2024. Earlier on 3/3/2024, this court, while allowing the BLAPL number 1079 of 2023 and 11625 of 2023, granted 3 months interim bail to the petitioners on the ground that the petitioner number 1 is terribly ill and there is no one in the family to look after the petitioner number 1. Hence, the petitioner number 2 is also extended 3 months interim bail to take care of his father, that is petitioner number 2. However, they did not surrender after completion of the interim bail period, which expired on 1/7/2024. Hence, the UP order has been passed by the 11th District and Sessions Judge, Umar Court. Mr. Das has placed on records various documents, various medical documents to and submit that as per the document, the petitioner number 1 has suffered 2 heart stroke. Apart from that, he is undergoing a regular dialysis, regular dialysis. And he submits that the petition number 2, the son of the petition number 1, is going to donate the kidney to his father. Therefore, he is pressing for the extension of interim bail for a further period of 3 months. 3 months. However, Mr. Das failed to place on record any document suggesting that the petition number 2 is the donor for the kidney, for the kidney. The result of the medical document placed on record, however, reveals that the petition number 1 is terribly ill, and sending him to the custody is no full purpose would be served to send the petition number 1 to the custody, because which would definitely mar the ongoing treatment. Therefore, I am for the considered view that the petition number 1, Pradeep Kumar Das, is entitled to interim bail for another period of 3 months. 3 months. In the meantime, if the opposite party number 2, if the petition number 2 the sample of the petition number 2 is accepted as the valid donor, kidney donor to his father, he may also apply for the interim bail in case in case medically the petition number 2 is accepted to be the donor of kidney donor for his father's kidney. 3 months to begin with. The trial court is accordingly directed. The NBW issued against the petition number 1 is set aside, and the trial court is directed to release the petition number 1 for a period of 3 months. Interim bail for a period of 3 months, and such submission has been taken properly. Yes. So far as 2 is concerned, if his this thing is accepted as a donor, this thing, to whatever formalities are there, you can also move application and come out and give whenever the operation is finished.
Only thing, your lordship is asking. Only thing is that by then he will be arrested and put to
Go and surrender. I'll just protect you till 30th of April. Insofar as petition number 2 is concerned,
grateful, my lord.
Insofar as petition number 2 is concerned,
My lord, it's a great
I am rejecting the application of his application for grant of interim bail at this stage. Therefore, he should appear before the court, surrender before the court on or before 30th of April. Till then, the execution of NBW issued by the district and session judge by the order dated 4/12 Jovita, order so and so.
4/10/2024.
is state. Yes.
Grateful.
Go and appear on that day.
No.
Yes.
And in the meantime, if he has got the document, then he
can move application.
Move application into
Yes.
It is it.
None appears.
May I please yours? I am password one password.
See the time.
Tomorrow.
And permanently pass over by dismissing.
Madam, he has challenged the cognizance that first the affair was launched by the sister-in-law of the OP number 2. In that case, charge sheet was submitted against 3 persons out of 6 persons, and police shows that the injuries are simple in nature. Subsequently, the OP number 2 and their family members, they obtained injury report under the RTI Act, which are grievous in nature. Then after they have filed a 1cc case. The 1cc case, the London court below has taken cognizance by inquiry under section 202.
How, if it was grievous, how earlier it was given?
I am showing that. I have already marked my guide. Pencil mark I have given. In the charge sheet copy I have. I will kindly see.
Where from police got simple injury?
They were initially treated at Jaleshwar. He has written my lord. Then they were referred to Baleshwar headquarters hospital.
That order was not.
Headquarters hospital. Police obtained injury report from the Jaleshwar where he was initially treated. And showing that the injury is simple, they were released on 41A notice.
Okay.
My lord, that I have marked in pencil.
Now charge sheet is filed for 326.
My lord,
Charge sheet filed.
charge sheet is submitted on section, my lord.
What are the close?
Yes, my lord. 323, 341, 354, 506, and 294. Then, my lord, he has filed a complaint case that he has annexed that cognizance order, page 18, my lord.
Clear it down.
But the interim order has to take adjournment. For that reason,
No.
will not be sued.
My lord,
Though the problem.
having put number 17 item to 26, you just come. That's why I'm taking one passport.
Let it be next week.
Till then interim order.
But on 16.
That interim order, but that is the reason we are asking for a passport.
No.
Otherwise you never ask. Yes.
Malayan on 16.
16th week nahi, 21 wala week रहेगी.
22, my lord, 22.
Yes. Yes. How many minutes?
Next matter, your lordship.
Only week.
Next matter, freezing of bank account system of 23 lordship. And for us, the last occasion, my lord directed my.
85? 85?
85 lordship. Only since 2023, two accounts have been freezed by the vigilance lordship. And last
Have you got
occasion,
any
lordship,
instruction?
Yes, madam. I need 20 minutes now. Two cases. Madam.
two at last
But
occasion, lordship directed.
are you opposing it?
Oh,
Okay. Then hearing.
But last occasion.
Generally, what happens in the release, if wherever it's possible, he comes and tells release it, no problem.
Lordship, that. No, then I can itself I can argue on the authority of the other.
That's right, but he
of the judgment.
He has otherwise instruction. What he can't help it. He is to argue.
No, I'm not saying that if then tomorrow lordship I can. So
Not tomorrow. I'll just ketra meter lagila. Weekly, na? All are weekly. It will remain tomorrow. Come tomorrow.
Lordship.
All the weekly. These are weekly lists, na?
Weekly list.
It will remain. I'll not give date in anything.
What would you?
If you want an adjournment, it's all right.
No,
Otherwise,
I want to take up because
let it remain. Come tomorrow.
Tomorrow.
Anybody wants to ask adjournment, then I can. Let it retain.
Documents I have given you, lots wanted to in the last order passed in another single email. So I have supplied that to the secretary. Release of the passport.
Copy.
They do.
Upon reading, let it be there.
Sir,
Yes,
sir,
ma'am.
if sir tomorrow supplement will be taken, then weekly, sir, how to?
Which matter, madam?
Sir, I have a case today. 808 as today it is
Item
registered
number?
100 serial.
100.
Yes, sir.
Supplementary weekly.
Who is your lawyer?
Weekly.
Who is your lawyer? You are going to argue?
No, sir.
Who is your lawyer?
My lawyer is there, but today he is admitted.
No, who is your lawyer? Name?
Durga Prasad Mallik Sangram.
Okay, has he prepared?
Yes.
I'll take it up. Let it be tomorrow. It may be taken up. Tell your lawyer to come.
Yes, sir.
Tell your lawyer to come. If whenever, because these are weekly list, I am not going to disturb. It will remain. Whenever you are ready, you will get the time and.
Thank you.
Okay, thank you.